these days I'll be alright. There's nothing here that I don't like. Just being me, living through my scars as I watch the clouds near and far. Hard to live within the truth, the memories of my youth. I'm doing my best to get it together, no matter the storm of the weather. Living like I had nothing to lose, not allowing them to light my fuse. I know I can't be the only one, a different path I never dreamed I'd find. It's a beautiful day to start with own mind. Live your best life, I'm not crazy. Stay a while, don't worry about tomorrow. Live for today, one of these days I'll be alright. There's nothing here that I don't like. Just being me, living through my scars as I watch the clouds near and far. Hard to live what's in the truth, the memories of my youth. I'm doing my best to get it together, no matter the storm or the weather. Living like I have nothing to lose, not allowing them to light my fuse. I know I can't be the only one, a different path I never dreamed I'd find. It's a beautiful day to start with on my live your best life. I'm not crazy, stay a while, don't worry about tomorrow. Live for today, one of these days I'll be alright. There's nothing here that I don't like. Just being me, living through my scars as I watch the clouds near and far. To live within the truth, the memories of my youth. I'm doing my best to get it together, no matter the storm or the weather. Living like I have nothing to lose, not allowing them to light my fuse. I know I can't be the only one, a different path I never dreamed I'd find. It's a beautiful day to start with on mine. Live your best life, I'm not crazy. Stay a while, don't worry about tomorrow. Live for today, one of these days I'll be alright. There's nothing here that I don't like. Just me and me, living through my scars as I watch the clouds near and far. To live within the truth, the memories of my youth. I'm doing my best to get it together, no matter the storm or the weather. Living like I have nothing to lose, not allowing them to light my fuse. I know I can't be the only one, a different path I never dreamed I'd find. It's a beautiful day to start alone. I live your best life, I'm not crazy. Stay a while, don't worry about tomorrow. Live for today.
Mike is muted. Mike is muted. Somebody say, your mic is muted. Your mic is muted. So I have in earphones today. We're going to try this a little bit different than using the big old burly headphones. We're going to do something a little bit different. Good morning. Well, I say good morning. It's actually afternoon. I didn't realize this shirt was so leafy. Leafy? Is that the word I want? See, I hate having two headphones in because then I feel like I can't hear. But I know that I'm going to be able to hear this trial better having these headphones in. So, anyways, so last night while we were streaming, look, I'm over here trying to put my earrings in. I can't even find them through my headphones. Wait. I gotta have my earrings in, y'all know. It's kind of like leaving the house, you got to put your earrings in to leave the house. You got to have your phone in your hand. Well, I got to put my earrings in to leave the house. And then I got busted this morning. Hectorius is running through TikTok looking at things, and he's going, oh, look, I know this person. fucking asshole. He was looking at my TikTok. He was like, "Oh, you did a TikTok last night." I'm like, "Yeah, I was bored. I was so out of my mind bored. I had to find something to do." So I'm sitting here doing stupid TikToks. Y'all know I'm just I'm and and Walmart delivery came. Walmart delivery came. So guess what? I have lemon pound cake. So I hope everybody brought something to share. I hope you all brought something little to share with. I also have a whole thing of cheese balls so the dogs have something to keep them busy. Because they'll be over here begging and it'll just here in a minute they'll be over here. Oh, mom's life. It's time to go bug her. So I packed up some cheese balls. I have my full to the top coffee. We're going to rock and roll this bitch today. I have watched a little bit of the trial. We have juror issues. We have people bringing in notebooks. We just all kinds of little things going on. I didn't catch it all, but I did catch some. So what we're going to do, we're going to roll the intro, and then I'm going to say hi to everybody. So let's go.
Rubber around the model room welcomes all. Thanks for stopping by, answering the call. Ups and downs are normal for some of us. Many days I beg to get off this life bus. Neon lights flicker, my shadow on the wall. Dreams on the ceiling, we run and then we fall. Sharing stories over paper cups. Wheels keep turning but never enough. Life's a ride on a rickety old track. Holding on tight, never looking back. In the rubber and mono room we confide. Laugh, cry, love in this crazy ride. Dusty postcards from the edge of nowhere. Heartbeats echo in the electric air. We dance on tables without to wait. Cry in the rubber and mono room, we're all high.
So I'm going to start off by saying good morning, good afternoon, good evening, whatever time of day you're in. Southern was here way before everybody else at 3:32 this afternoon. And Cindy be popping in. And we have Teresa. Good morning. Yes, Teresa, you made the non-vertical. Imagine that. You made it. And of course, we have the Mastiff is always over there holding down the fort in the kick, because we do have kick. I do stream on Kick while I stream on YouTube because, hey, why not? We can. And look, we have the duck butt. We have the duck butt. We have the duck butt. Y'all know me and my duck butt. I love it with my meat. With my meat. You haven't had morning breakfast yet. Teresa, go eat some breakfast. I had to wait for Walmart delivery because, I don't do anything until I get my grocery delivery. So I'm sitting up front waiting on grocery delivery because here it was already 2:30 in the afternoon and I needed to cook my breakfast and got waiting on the bacon around here. So finally got my Walmart order, made my honey his breakfast, got him off to work. And I was sitting on the couch lounging and I almost dozed off. I got so comfortable over there with the dogs sleeping, with Lola sleeping on me, Meat's over there in the recliner sleeping in his little spot. And I was like, oh God, I could fall. Sheila, you better get your butt up. Better get your butt up. So here I am. And I haven't eaten. Everybody else is eating. I did give mom a piece of pound cake to hold her over. So that'll keep her busy, hopefully for a little bit until couple hours. So, oh, yes. Spicy. Hannah is doing laundry and making her bed. Hannah, do you tuck the corners in? Do you tuck the corners in your bed? Because I couldn't sleep in your bed. First thing here's total squirrel moment because I'm off the wall just chit-chatting over here. Total squirrel moment. That is what I hate about staying in hotels is having to untuck all them covers. I'm like, dude, this is just too much. This is too much. Pull all these corners out. Don't tuck my corners in. I need to move. I need all that. The person on Kick is C Mastiff, Teresa. C Mastiff sticks around over there. Keeps it on the down low for me. Not a lot of people go over there. It's just I've been streaming over there, gosh, probably, it was April of last year, so April, May, May, because it was after my birthday, so it was May of last year when I started streaming over there. It only saves for 7 days, but it's there. If I pick up subscribers, I pick them up, I enjoy it. I mean, I'm here on YouTube, I do it on YouTube, but, shit, if it shows over there, I don't care. I tried to get it to where it would do the Facebook, not Facebook, Twitter, but it won't let you do Twitter unless you're a paid member. And you know what? I ain't paying Twitter nothing. I ain't. We ain't paying Twitter. I'm sorry. I pay enough everything else. We ain't paying Twitter. Although I have to tell y'all, I did get an excitement yesterday. I overpaid my Lane Bryant credit card, and I got a refund check from Lane Bryant yesterday. I got so excited to open the mail. I'm like, what's this shit? Why are they sending me a bill? I pay every month, and I go rip that damn envelope open, all pissed off. Open it up. It's a refund check. I was like, oh, how nice. I've been overpaying. I've overpaid for like 4 months. So I got extra little bit of cash. So I think I'm going to splurge and buy me dinner tonight. So, you know how much fun that is. And I just got a text. You know what? Y'all people out there need to behave. Sugar Ray Leonard home. The police were called to Sugar Ray Leonard's home today because there was an intruder arrested for a restraining order violation. Y'all behave out there. Leave Sugar Ray Leonard alone. This old man, he don't have time. Oh, shit. Oh, well, you know what? Let me just bring this up and let's read this real quick because now because, well, here, I'll just read it from here. I read it from here. I'll read it from my phone. Just, we're going to read real quick. We're going to have a real quick reading lesson before we jump in this trial. So Sugar Ray Leonard's son left the boxing legend home in a cop car. It was his son. Y'all, okay. See, I sitting over here saying y'all need to behave out there, but damn it. Okay, look, yeah, Sugar Ray. You look, I'm gonna pull it up over here because now I'm gonna show y'all because I'm not. Y'all know I don't read shit and just like look. I put sugar and it automatically comes up Sugar Land, Texas. Because that's where I'm from. Sugarland, Texas, home of Imperial Sugar. And Southern's back. Welcome back, Southern. Okay, so look here. Let's do this. We're going to do this. And we are going to drag this over here. I believe y'all can see that. Here we go. Add to stage. So, Sugar Ray Leonard's son arrested at boxer's home over restraining order violation. Sir, if you're not supposed to be at your daddy's house, then you stay the fuck away. I'm sorry. Sugar Ray Leonard's son left the boxing legend's home in a cop car for violating a restraining order. Okay. I don't know why. I don't know the scoop, but I might need a little bit of the tea. Why does he have a restraining order against his son? Law enforcement tell us 911 call was made by Leonard's security team early Wednesday morning. Daniel Ray Leonard, 25, allegedly tried to enter the residence in Los Angeles by turning exterior door handle. Well, you know, that's usually how you enter a residence is by turning the damn handle. Okay. We're told when officers arrived and met with security, Daniel was located at the pool house and was promptly arrested. Well, was the pool house his original home? I'm just asking for a friend because we were initially told the suspect was known to the family, but it turns out he is literally family. Daniel Ray Leonard is Sugar Ray's youngest of 4 children, whose mother is Bernadette Robbie. Okay, here's Daniel was ultimately arrested for violating a restraining order. Daniel's pops is one of the greatest boxers ever with a 36 3-1 record, earning championships in several weight classes. 7-year-old Sugar Ray fought. Reach out. Okay, I'm sorry. Why y'all. Okay. I need to know why he had a restraining order against his son. I need to know more. I need to know what's going on. Y'all quit screwing around over there. Be nice to your parents. Put them in nice old folks' homes with bingo and bunko, you know. Be nice to your parents. Damn it. Y'all got me all riled up. See, I saw that Sugar Ray Leonard and I started to read it, and then I was like, nah, nah, I gotta open this up and read this to everybody because y'all people gone off the rails. Be nice to your parents. You hear me? You hear me? Muffins. Muffins ain't in here, but I'm still preaching to her. Okay, let's get to the trial. We're gonna start off. So somebody from the audience wants to speak at first. Hang on just a second. We're gonna get there. Because with the luxury of Zoom, we're gonna zip through this shit. And we have subtitles today. Okay. Okay. So I need to make sure y'all can hear it because even with these earbuds in, it's still a little low. And I was gonna uh 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 boost the volume. Um, but I want to do it very, very methodically because I am not busting anybody's eardrums. So we're gonna hit that. We're gonna take this and we're gonna turn this down. Okay, so it's gonna be just a little bit louder than what it was, and we can take it up from there. I know subtitles. And I looked ahead. There ain't no good videos. These people punked us yesterday. We ain't getting no good videos from what I seen a little bit that because I kind of skimmed through. I was disappointed. The judge isn't happy. You hear nothing, and it took y'all that long to tell me you hear nothing. Y'all suck. Okay? Look, here. I'm just going to verbally abuse y'all for a minute. Y'all suck to let me know that it took y'all that long to tell me you heard nothing because I shared it a different way. Y'all suck. Y'all should have told me. Now I feel bad. Oh my goodness. Okay, let's try this again.
Without an objection, I would never have known to file a motion in limine on. So they had to tell me they were objecting to those business records.
Okay. Let me back
Business
them up a little
records
bit.
exception. And those are evidentiary issues that without an objection, I would never have known to file a motion in limine on. So they had to tell me they were objecting to those business records.
Okay, so they're objecting to the business records and all that. Remember the damn book we talked about yesterday? The handbook. Oh God, my words, Sheila. I do not like this. Y'all, I'm gonna have to go change my shirt. I don't like this shirt. It makes me look so pale. That's not my makeup. It's green and black makes. I'm sorry. I'm like freaking out over this right now because every time I look down and I see myself down here in this little camera in the corner, I'm like, God. Okay. So anyway, so the book, that squirrel, Sheila, squirrel. I'm telling y'all, I'm all over the place today. Because I was really about to fall asleep. You was deaf. Hannah was deaf. Y'all like my shirt? You know what? I'm gonna tell y'all when I saw it on. Okay, here. A piece of honesty, because rubber's too honest sometimes. Rubber says too much sometimes. Look, I tried to send a super chat today to somebody and I couldn't send it, and I got all flipped out and freaked out, and I'm like, what the fuck's wrong with this? Why can't I super chat this person? I was mad. Anyways, y'all, I told y'all I'm having squirrel moments today. A shade darker. Yeah, I know. And I thought maybe turning the light down. And I didn't there's nothing on my face. This is all my skin. There's nothing on my face. I just put lipstick and eye stuff on. This is my skin. This is just my natural color. I did put eyebrows on because, they're blonde and Muffin says I look funny without eyebrows. But no, maybe it's the color of my camera. I don't know. Maybe I need to work with that more. Anyways, so this book, back to this book. Remember the book we talked about yesterday, the handbook, the procedure book, security. That's what I was going to tell you. The shirt. I thought it was marijuana leaves. I thought the damn thing here. You know what? Put me back big. Look, I thought it was marijuana leaves. It's damn fern leaves. Okay. When I saw this damn thing online and bought it, I thought it was some MJ leaves, but it's not. It's damn fern leaves. So I got screwed. Hey, Mustang, we're just getting started. We are just getting started. Okay. I'm a little off. I'm a little off today. I'm a little off. People are going to make fun of me if I don't shut up and hit play. So we can hear now. We got the sound. But anyways, the book comes into a big safety. Thank you. See, I knew Cindy would know what I was saying. I don't even have to say the words right. And Cindy can she'll pull them out. She knows what I'm saying. Safety procedure manual. Yes, that comes into question. We have teachers that are going to testify today. It's crazy. Okay, I'm going to play. I'm going to be quiet.
Okay, and to the business records, and the other exception was?
The two exceptions that apply to the documents, I think both exceptions apply, are the public documents exception and the business records exception. And of course, I'll provide more detail on that if the court wants me to go ahead with the motion as a motion in limine.
And to the three things you would like to introduce into evidence, do the two exceptions apply equally to all three?
No. As to the video, it is a statement of a party opponent. It is an interview of the defendant by the witness who I will have here on the stand. So the business records and public documents exceptions, I wouldn't seek to apply to the video, but I would seek to apply to the policies of Richmond.
All right, thank you. All right, to Mr. Rogers. So what is your position now? They're seeking to introduce it.
Your Honor, of course, I would have liked to have seen this motion in writing so that I could properly respond to each of those stated exceptions to the hearsay rule if they think it applies to these documents, so that I would be able to have statutes and case law to defend against having those things admitted. Regarding and this is Farish's testimony. Her testimony is going to be her testimony. I believe the Commonwealth is going to have a problem authenticating the video, so she can testify as to what she saw and observed, but regarding the playing of the video, we're going to be objecting on an authentication basis.
Okay, so let's break this down. 2, portions of the Newport News Public School handbook, which Commonwealth is seeking to introduce. Let's not call this a motion limiting, but they're seeking to introduce. What's your position today?
Your Honor, my objection is going to be it's hearsay. It's going to be offered for the truth of the matter. So
okay, so let's deal with that. So the hearsay, and Commonwealth has already responded that they believe it falls into the exception of public documents and business records. What's your position?
My position is it does not. It's not a public record.
Trying to put those little closed captions in a good spot. I don't need it over my words. Y'all need to know this is my room. Oh, by the way, welcome in. Thank you for joining the Duck Pond and being here with Rubber Ramada Reviews and hanging out where we let shit just flow off our back and we keep our feet in the pond so they stay clean and our little, we no dirty feet in my chat and chat away, enjoy, say what you want to say, be snarky, be nice, be, you know what? Be yourself.
It's a internal document that governs the policy of the Newport News school system. And regarding a business record, if I could just look at
Yes, please. Okay, and let me pull out my rules book.
Oh shit, she's getting that book again. She's getting that book again, y'all.
And Ms. James, if you could point me to this section in the rule of the Supreme Court.
Your Honor, I have several citations that relate to the.
Okay, we're going to go over all that, which is not a lot of info that we really care to just keep letting them rehash.
Okay, and so that we have a game plan for when she comes out here.
Plan and its annual updating is required by law.
For the Vanderbilt Court.
Okay, this is what I wanted to get to. I was trying to get to the part about the safety book.
Unless the document relates facts or events within the person that
apply to the Newport News Public School handbook. Thank you. So the hearsay exception of public records and report does apply to the Newport News Public School handbook. And we can distinguish the cases as Williams refers to the CCRU, which is a criminal record database and history, again, which is a different public record. And again, there are exceptions for public records compiled by law enforcement. And then again, defense has already distinguished the civil case. But this clearly falls within the statute as a permissible exception to hearsay. So the Newport News Public School handbook comes in. Now, the Enrichment Crisis Management book. Can you first explain to me what this is? I don't know. I need more understanding.
Yes, I can proffer that if the court wants. Dr. Farish is here and knows more than I do. But the crisis management plan is a document that the school board is directed to require individual schools to create and to update annually.
That was the one, the crisis management plan. That's what it was. See, Cindy, we were so close, right, Cindy? What did you say it was? Let me scroll back. What did Cindy say it was? Safety procedure manual. Okay. We're close. We know what we're trying to say, but see, the problem is Cindy's over there talking and Sheila speaks. And oh, you know what? I know y'all probably, some of y'all know this and some of y'all don't. I'm talkative today. I'm sorry. I used to be Sheila Sews. S-E-W-S, because I sew. I love to sew. I've always sewed. I've sewed clothes. I've sewed dolls. I've sewed all kinds of things, curtains and blankets and quilts, and I've done quilting, all that, all my life. So my screen name used to be Sheila Sews, S-E-W-S. Well, if you know of Recovery Addict, his name is Scott. He is another creator on this platform. He does great work. I used to watch him a long time ago. I say a long time ago. It's been about 5 years. And when I first started going into his chat and he would highlight my name, he would call me Sheila Sews. Sheila Sews. S-E-W-S. Sheila Sews. So I got embarrassed. because I was like, no, I'm not suing anybody. I'm not, don't put Sheila sues. Don't say that. So I changed my name to Sheila Says. So everything that I typed was Sheila Says, blah, 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 blah. So you're in the right book, just the wrong page. So it wasn't Sheila Sue's. Yeah, I was in the wrong page, right? So I was like, okay, no, we got to change the name. So I changed it to Sheila Says. And then from Sheila Says, I went to Rubber Ramada. So it's really funny. And I think about that a lot when I think about sewing things is Sheila Sue's. And it goes back to Recovery Addict, but where I had to go change my ID because it was so funny. And I went back and I looked because I thought, no, surely I must have imagined it. And I went back to some of his old streams. And when you go back on replay, it shows my name now is Rubber Ramada in the chat. But when he highlighted it and he put it up on the screen, it said Sheila Sews and he called me Sheila Sues. So I was like, okay, nope, we can't use that anymore. Okay, sorry, I'm squirrely.
Comes from Virginia Code 22.1-279.8D, where the school board is required to ensure that every school in the district produces a crisis management plan, reviews it annually no later than August 31st, and then the school board certifies in writing to the Virginia Center for School and Campus Safety that annual review has been done each year. So it is a report, it is a plan required by statute. The contents of the plan generally is it outlines how faculty are to respond, and employees, faculty and employees, are to respond to all various manner of crises that could occur in a school building, not just violence, but just any sort of crisis, a fire, a natural disaster is covered, but many things are covered.
Are there scenarios that are factually close to the facts reported, in this case, covered in the crisis management book?
Specifically in the crisis management book, there are instructions both on what to do if a suspected weapon is in the building and what to do if an armed student may be in the building.
Okay.
And let me just add, Judge, exactly in both of these documents that I'm seeking to admit, my plan is to just admit the portions I believe are relevant via the testimony. And I wouldn't even seek to introduce the entire document. However, if the defense wishes for completeness to introduce the whole document, I would not object to that either.
Okay, and then you said you had additional argument on why this is admissible.
Okay.
If you'd like to go into that now so that they can get their cases together and be ready to respond.
Yes, Your Honor. For the crisis management plan, the strongest.
Oh, sir, found the microphone. Hold the. So hold up, y'all. Let me adjust this again, cause sir here found the microphone, and all of a sudden we got loud in my ears.
Argument for its admissibility is the public documents exception. And that's because they are required to do it by statute. And that's one of the requirements of the public documents exception, is that either it be required by the nature of the duty or it be required by a statute. And here it is required by a statute. That statute is 22.1-279.8D, where the creation of the management plan and its annual updating is required by law. Given that, it qualifies as a public document, and we should be able to authenticate it by use of the custodian of records who is here. It is also a business record, I believe, Judge, for the same reasons that the manual is a business record, but I believe the stronger grounds for its admission is the
So they debate a little bit over this, bringing this record in, over this custodian of records to come in and authenticate this book and this document.
Yeah,
That's the big dilemma right now.
Of course, the nature of the interview, that setting, and whether my client felt like she had a right.
Okay, they're talking about an interview, which we will see the interview in a little bit. Now, here we go. This is where I wanted to get.
I believe that the court should instruct the jury members that they don't have to rely on the memo.
Let me rewind this.
observe any other jury members discussing anything pertinent to the trial.
Okay, I'm gonna boost the volume because this is kind of hard to hear right here. I'm gonna back it up just a little bit because this is where they go in talking about the juror problems. Okay, here we go. Jury problem. Jury problem. Jury problem. See, this is the luxury.
See the jury box. Thank you.
I will speak one time and I'll be quiet for maybe 5 minutes or 10 minutes. But this is the luxury of being able to do this a little bit later, zoom, and I kind of know a little bit about it so I can skip the fluff and crap. So let's roll.
Good morning to you.
Good morning.
Okay. And I do want to remind you, of course, you're not being recorded. You're not on video. You can have a seat. Your face and information will not be displayed to the media. Okay, so first, I did receive the answer to your questions and I have 2 responses. And my responses are required by law. One, you have to rely on your recollection of what the evidence is. And 2, evidence is still being presented to you. So please don't make decisions or deliberations until the case is given to you for deliberation. And that would be at the conclusion of all of the evidence. And I can't, you have to rely on your recollection because the court doesn't want to give undue weight or influence or suggestion to any one piece of evidence over the other. So that's why I'm not answering the specific questions. So I don't mean to be rude or disrespectful, but you have to rely on your recollection. So now, we had 1 question for you, or maybe 2 questions. Are these your questions alone, or have you discussed this with other jurors?
No, my questions alone. Like yesterday, we had it, and it was like, and I guess I missed some of that information when it was given because I wasn't writing everything down. I wanted to listen to everything that was going on. So I may have missed those answers to some of that.
Okay, understood. And have you observed any of the jurors discussing the case? Because they're not supposed to discuss the case until it's given to them for deliberations.
No.
All right. Thank you, juror number 38. One moment, let me see if the attorneys have any follow-up.
Me and you both, Cindy.
I don't.
I think of it.
Okay, all right, thank you very much. Yeah, you can go back to the room, and we have one more thing to do, and then we'll get started with evidence today. Sheriff, the gentleman in the back row far right, you know who it is?
So they did have some discussions. She had written a letter. They had written a letter to the judge, and they discussed it, whatever was about that letter, from what I'm understanding on that. Now they're going to bring another juror in, and this is going to be about a notebook.
Oh, okay, yes, so bring him out. I don't know his number. Oh, good morning, sir. You're welcome to have a seat. Thank you very much. And you can give me your juror number.
Juror 33.
Thank you, juror number 33.
Juror
And then I
33.
do want to remind you, your face is not being filmed and your information will not be released to the press. Yesterday you had a question, and so we would like to hear your question, and then we'll decide how to respond, and then we may have questions for you. So yes, sir, juror number 33, what was your question?
In this case so far, there have been a number of objections and information we've been told to omit from our consideration. In the event that while we are taking our notes and trying to recall information, we are unclear about what information is to be omitted, are we allowed to ask for clarification from what point in the witness testimony or from what point in conversation we are to omit from?
Okay. And I'm now going to turn to the attorneys. My position is by law that we give the response of you have to rely on your recollection as best as you can. Just come up with a different response.
No, not on that issue, Judge.
Does the defense wish a different response? And I do understand we're going to ask some other questions about the weed part. But Mr. Rogers, just to, can the court clarify the objections and what was stricken and not stricken?
I don't have a problem with the court clarifying,
Okay,
as it did before.
what, giving the same response or offering clarity? Giving the response that he has to reply, the jurors have to rely on their independent recollection.
That satisfies the defense.
Okay. Ms. Steve?
Yes, Your Honor, I think, my clarification that not only do they have to rely on their own recollection, but again, to instruct them that anything that you have ruled that should be stricken or should not be taken into account should be just done just so, considered or handled just so. They cannot consider it.
Okay, thank you. Okay, so, juror number 33, and that is the response that the court is required to give by law, is that the jurors have to rely on their independent recollection of what the evidence is, and they cannot consider something that's stricken. Now, I understand your point, but what if I don't remember what was struck or not, and I got confused in the sustained, overruled, you can consider this, you cannot. Again, you have to rely upon your recollection as best you can. The fundamental principles and the Supreme Court law regarding that are that I don't want to, they frown upon the court giving emphasis to certain evidence over another. So that's why we don't try to clarify. You have to receive it and make your best judgment. Because if I point it out for you, that can give it undue weight. Now, you use the word "we" several times. Why do you use the word "we" and are you discussing that? Have other jurors expressed the same confusion?
The other jurors did not express that confusion to me. I posed that question to the other jurors and none had an answer.
Okay, and other than that question being posed to other jurors, have they discussed the case? Are you observing anyone discuss the case?
Okay.
Okay, and the reason why I ask is because you're not to discuss the case, which is deliberate, until it's formally given to you at the conclusion of evidence. So there have been no discussions about the case.
Okay.
Okay, all right, I'm going to turn to the attorneys to see if they have additional questions for you.
Understood.
All right.
We don't have any questions.
Okay, Mr. Jacobs.
I don't have any questions.
Okay, thank you, juror number 38. You can retire to the room. We have one more thing to take up and then we'll start the case.
Quick correction, Judge.
You have a question?
No, quick correction. Just now, we referred to him, the court referred to him as 38. He's
No, 33. Thank you.
33.
Juror number 33. I'm sorry. Thank you. You retire to the room, please.
Happy birthday to your daughter, Journey. Sorry, I didn't want to interrupt him because we've been trying to get here. I've been talking for 30 minutes and all I wanted was 5 minutes of this lady talking and I keep talking.
Okay, anything that someone would like to address before we bring the jury down?
Your Honor, can I just step out for a quick minute?
Yes, sir.
All right, he steps out. Judge steps out.
Well, I know number 38 it is based on what they actually suggested to.
Okay, but the problem is when they come back, here we go back. Here we go. Y'all ready? We still have that juror problem. Oh my goodness, Journey. That's a lot.
Judge, with respect to the issue with number 30.
Sorry, Journey. I read that as 5 kids plus 4 boys and 1 girl. So I was thinking like 10. So that's why I said that's a lot. I misread that. But 5 is okay. 10 is a lot.
33, sort of announcing this question to the panel. I share the defense's concerns about that. It sounds to me like the question almost suggested to them that they should be confused about it and started to start them reasoning over the evidence. So I share their concerns about 33. I don't share the concerns about 38 that were mentioned because I can't change what my evidence is based on what they asked. Like I couldn't suddenly admit a 911 call because no 911 call was provided in discovery. You wouldn't be allowed to do that, for example. However, and while I know number 38, I feel like number 38 has, begun to form conclusions in her mind about the case as well. And given that,
So they already feel like 38 has formed a conclusion because they talked to 33, and because 33's. So I'm telling y'all, we have jury problems.
I think I have to agree with the defense's motion.
I will recess to consider this. Again, we also have 2 alternates. So we could release jurors 33 and 38 and still have 12 jurors. But I do understand your concern that, again, let's parse this up. Juror 38 were her questions alone and were not shared or disseminated with the other parties. So if there are concerns about juror 38's questions, juror 38 could be released as an alternate, and we still have a constitutional jury panel. Juror 33 did ask his questions of the other jurors, and we're
going to play musical chairs.
Respond and follow the cautionary instructions that the court did give not to deliberate until this case is given to you for deliberation. And now, let me add to this. The sheriff has indicated juror 33, the gentleman does have a notepad back there that was not a notepad court issued, but we don't know what's in the notepad. Let's bring him back out again and see what's in the notepad. Well, hold on, Sheriff. Yes, Mr. T.
Just for the record, regarding juror number 33, his testimony, from what I recall, was not that they did not answer him. He said that they didn't have.
Oh, they said it. Yeah, you're right. They didn't know.
Right. So there's, to me, that indicates.
So let's follow up on that. Yeah. Okay, bring out juror number 33 again, please.
The only thing I can think of with the why no 911 call is because they had resource officers there at the school, I'm assuming, and probably radioed through that way. That's the only thing I could think of, because that was the first thing I thought of was why no 911 call? Why? How can you have a shooting at a school and not have a 911 call? But I mean, unless it was radioed through officers, they already had officers that was, I don't know, and I want to know now. And now we have this ding dong that brought a notebook from home. You're 33. Step on up.
Okay, and you can have a seat, juror number 33.
Thank you, ma'am.
Okay, we 2 questions of clarification.
Absolutely.
I do understand you said you asked your questions of the other
Southern?
jurors, and if you could give me the detailed verbatim responses you received, whether it was they did not answer you or they said words, if you could give me the actual, your recollection of those conversations, and with how many jurors?
My recollection of the conversation was when I posed the question, our officer here, and he said he could not answer it, which presented to you.
And you posed questions to who? Oh, okay, gotcha, the sheriff, okay?
Yes.
And he said he could not answer
Could
it.
not answer those questions for the judge. When he stepped out, he said, I'm just curious about making sure that our information is accurate. Trying to remember verbatim the responses, but generally it was just I apologize, I did not try to log that in my memory.
apologizing right now is not anything. We just need to carry on because this is now we're playing musical chairs, right? Some have talked to cops. Some I have no clue. This is just went total off the rails. That's what I'm saying. They confused the hell out of me this morning while I was trying to watch this, and I was like, maybe I'll understand it better with y'all. Maybe I'm the one missing something. Okay.
I don't remember any particular responses as much as that might be good to clarify or be good to know. The conversation moved on, I believe, to traffic cameras. So, I believe that was the extent of the conversation. I'm sorry, I can't be.
So your memory is fine. And, so did were there responses or did they reach you with silence? Did you receive responses to the question?
The only responses I can recall to any extent was the general assent that clarification would be good to have.
Okay, and how was that general consent, that clarification would be good to have conveyed to you? Was it a physical gesture? Was it a verbal?
Verbal responses to the extent of something to the effect of, oh yeah, that would be pretty good.
Okay. And do you know how many would have shared that? If you can approximate.
Maybe 3 or 4 people at most.
Okay. And those are my questions for you, but again, as procedure, I'm going to turn to the attorneys and see if they have additional questions.
So you just sort of in passing mentioned that the conversation moved on to traffic cameras.
Yes.
Is that right? Was it like, could you describe the nature of what that conversation was?
Trying to remember because it was going between considering my question, sipping my coffee, and generally paying attention to traffic. So I apologize if this is not totally specific.
This man just said sipping his
We're
coffee.
trying very hard to not discuss the case in any capacity. So we're finding other topics of conversation. People were discussing time to have been clocked by traffic cameras.
Okay, so
that whole thing.
Sure. So it wasn't in relation to is there traffic camera evidence in going to be shown in this case? Okay.
No.
Oh, thank you. I don't have anything further.
Okay. Mr. Rogers and Mr. Teague?
Yeah, me too, Teresa. I think 33 needs to go on.
And then you remember 33. It was mentioned to me that you had an extra notebook. Are you reporting any notes from the trial in that extra notebook?
The extra notebook was the initial notebook I brought in. I was unsure if notebooks would be provided to us. I left it here with the other one. I believe it just simply says jury notes and the date. And when I heard that we were not allowed to take other notes, the notebook was placed down on my feet and has not moved from that position.
Okay, wonderful. Thank you. And so again, because I changed the topic, I'm going to turn to the attorneys to make sure they don't have any additional questions.
None from the Commonwealth.
Okay, thank you, juror number 33. Again, you were not in trouble, but we just have to make sure everything is perfect.
They're going to play musical chairs. You
retire
watch.
back to the jury room. Thank you very much.
Thank you, ma'am. Thank you, Vincent.
Okay, anything additional before I take a recess to research and consider the issue? The mistrial motion made based upon juror number.
You did hear that right. The mistrial motion made. What?
33 having conversations with the other jurors. Motion made based upon research and consider the issue. The mistrial motion made based upon juror number 33 having conversations with the other jurors.
My position remains the same.
Our position remains the same, and just want to note that the juror seems to not remember, not remember exact conversations that went on regarding the issue.
So again, I'm going to retire the deliberations. Just for human planning purposes, it'll probably be at least 15 minutes. So people.
Okay, so she goes and she does her thing, and she's longer than 15 minutes. She tells us a bogus story here because she's longer than 15 minutes.
Decision and a curative instruction can be given, and I will again bring them out and tell them that they are not to discuss the case as questions of the case law that the court is relying on.
The defense has an objection to the authentication of the video that the court has already considered. And
Advice or anything like that.
No.
And so
Sorry.
the
Dr. Ebony Parker.
I hit that button too fast.
To instruct their subpoena witnesses.
Full truth and nothing but the truth.
Okay. All right. So came back. We played musical chairs, and here we are. That was the morning. That was before we even get to the first witness on the stand. So now we are finally on the stand. Okay.
Deputies and watch your step as the stairs, and the chair and microphone are adjustable. And Ms. Ferris, we're going to take up some of your testimony outside of the question for the jury to look at any objections and evidentiary issues. And upon the ruling, we'll not bring the jurors out.
No, they just musical chaired.
So I just want to explain to you.
No, they just musical chaired. They just switched them to as an alternate, so they still have a 12-panel jury and they still have 2 alternates. They didn't make them leave.
Procedurally what's happening right now. If the attorneys have any questions, we'll start the combo. Yes, Mr. Ross?
Before the video started, I would like to coordinate her during the video part of her actually speaking.
Okay, and I don't know what order Mr. Jenkins is going into. Do you want to start with the questions, Mr. Rogers?
Judge, may I propose that I lay an authentication foundation, not play the video, let the defense counsel voir dire as appropriate, and then the court will rule whether she can watch the video to authenticate it.
Okay, yes, please proceed.
Good morning. Could you please tell us your name and how you're employed?
Nina Farish, Human Resources Director with Newport News Public Schools.
Were you employed in that same capacity in January of 2023?
Yes.
And as part of your official duties as the HR director, were you required to conduct an internal investigation into the shooting at Rich Neck Elementary School that occurred on January 6, 2023?
Yes.
As part of your investigation, did you have occasion to interview numerous people?
Yes.
Okay, total side rail. Lola is sleeping. She's fighting in her sleep. So if you hear any weird things, Meet's in the recliner asleep. Lola is dreaming. Before I have any crazy calls on me or anything, but I don't have dogs fighting. It's Lola's dreaming.
And technically, how did you conduct the interviews?
The majority of them I did via Zoom.
Okay.
Recorded.
And did you conduct an interview?
Okay, let's back up because I didn't hear what she did because I was so derailed with Lola over here. I was worried about. Okay, so she was the human resources person that did the interviews.
Were you employed in that same capacity in January of 2023?
Yes.
And as part of your official duties as the HR director, were you required to conduct an internal investigation into the shooting at Rich Neck Elementary School that occurred on January 6, 2023?
Yes.
As part of your investigation, did you have occasion to interview numerous people?
Yes.
And technically, how did you conduct the interviews?
The majority of them I did via Zoom.
Okay.
Recorded.
And did you conduct an interview with someone named Dr. Ebony Parker?
Yes.
And what was prior to January 6, 2023, what was Dr. Parker's title with Newport News Public Schools?
Assistant principal.
Okay. And do you see Dr. Parker in the room right now?
Yes.
Could you please just point her out for the judge?
Same.
I'd ask the court to recognize she's indicated the defendant.
So noted.
You've indicated I'll ask it again because I'm not sure what your answer was, but did you do an interview with Dr. Ebony Parker?
Yes.
All right. And was that was that interview conducted in person on Zoom or some other way?
Via Zoom.
Okay. If you were shown that video or clips from that video, do you believe you would be able to recognize it as the one you created?
Yes.
Okay, thank you. For now, I don't have any other questions for you, but defense counsel, I think, does.
Good morning, ma'am. How are you? Great. So, regarding any video that was produced, did you keep, or were you the sole custodian of that Zoom video?
Yes.
Okay, and where was that video maintained?
On my computer.
Okay. Did anybody else have access to your computer, or was it just you?
Just me.
Okay. Did you provide a copy of the video to anyone?
Yes, when asked by the attorneys.
When you say the attorneys, what attorneys?
The ones that represented the school district.
Okay. Did you provide a copy of that video to Mr. Jenkins, the Commonwealth?
No, I'm trying to remember the name of the law firm because, as I recall,
so the civil attorneys?
Mr. Jenkins was not the original attorneys.
The civil attorneys?
Correct.
Okay. So have you gotten a chance to review the video that's in the possession of the Commonwealth?
Yes.
When did you review that video?
I reviewed the copy that I still have, and I reviewed it to refresh my memory.
Okay. I want to make sure that you understand my question.
Okay.
The copy of the video that the Commonwealth has, have you reviewed that?
I'm not sure how to answer that question because if I didn't give it to the Commonwealth, I don't know which video then you're referencing.
That's right. So you did not personally give the Commonwealth attorney a copy of the video, and you're not sure that the video that the Commonwealth has is an accurate copy. Is that correct?
That's correct.
Okay. So the video that the Commonwealth has, you don't know if it's actually been altered. Is that correct?
That's correct.
Okay. So you don't know how many hands that video has gone through before it actually came into the possession of the Commonwealth. Is that correct?
Correct.
Okay. So you really can't verify the accuracy of the Commonwealth's video.
Correct.
Okay. Can I have a vote, Your Honor?
Yes, sir.
Okay, and this recorded video, is it stored in your office, or is it stored in the cloud someplace, or is it stored on Zoom's the Zoom app, or how is it actually how is it preserved?
It's on my laptop.
Okay, so you actually have a copy of it on your laptop.
I would call it the original because I've never accepted when subpoenaed.
Okay.
Made a copy.
Okay, and again, you provided that to the civil attorneys, but not to the Commonwealth.
Correct.
Thank you. I'll tell you what, let me just keep that.
Good morning, Ms. Stairs. Regarding the video that you're saying that you recorded, did you record it or did the Zoom platform record it?
I pressed record, but it was the Zoom platform that's recording.
Okay, so you did not actually record it with your own device or anything like that?
No.
Dude, that was a fucked up question. I ain't even gonna lie. Did you record? No, I didn't. I just. I'm gonna rewind that a second. That actually kind of caught me off guard. That really caught me funny. Yeah, no more pups for me. I thought I had kittens, but it was just one day during a rainstorm, and I think the mama came back and took them, and she just put them under my little shed thingy to get them out the rain. And she decided she was going to be a wonderful mom and took them away and didn't have to deal with them. So,
Good morning, Ms.
okay,
Harris.
let's pay attention. Push
Regarding the
button.
video that you're saying that you recorded, did you record it or did the Zoom platform record it?
Well, I pressed record, but it was the Zoom platform that's recording.
Okay, so you did not actually record it with your own device or anything like that?
No.
And so
Look,
the actual video was something that
Aquaman
you
has that
downloaded from
problem.
Zoom or was provided to you later via Zoom, correct?
Repeat that question.
You said, I believe your testimony is that Zoom recorded it. You pressed record on the Zoom platform
Correct.
and Zoom recorded it.
Yes.
And then you were able to, I'm assuming, download it in some way, or how did you get it onto your computer?
I have the Zoom app, so then I just reopen the recording
Mm-hmm.
and it can play for me.
Okay, thank you.
I have to tell y'all, I've never used Zoom, so I don't know how to use it.
There's any further questions before we?
Just arguments at this particular moment.
Okay, your arguments.
Here, there, pull myself here. Let me make this maximize that so y'all see her name. Her name is Nina Farish, so then I don't have to put the names on the screen. Human Resources. Yeah. I don't know how to use Zoom. So she's over here talking about the Zoom and recording and all this. Nope, don't know how to use Zoom. Makes sense. If she's Zoom recorded or screen recorded, makes a difference in these abilities to edit or not. Well, see, Cindy, you're one up on me. You're one up on me. Yeah, I thought I had kittens. No kittens. No kittens, Journey. No more dogs. No more kittens. I almost lost Lola I know you and I haven't talked in a while, Journey, but I almost lost Lola and all that. Nope, we're not doing that ever again. My dogs are fixed. Spay and neuter your pets. I believe in absolute taking care of your animals because, yeah, we're not doing that again.
Towards the video.
Your Honor, she testified that she cannot verify the accuracy of the video that Commonwealth has. She hasn't viewed it. She testified that she cannot verify that the whatever video Commonwealth has not been altered in some way. There's all sorts of ways to manipulate a video. It could have been run through artificial intelligence and altered. She testified that she can't. She's not.
Okay.
Verify that.
Are we not?
Do I have permission to play the video?
Have they been in our YouTube sector?
Do you want to say something?
I need to know.
Your
They've
Honor,
been dabbling in
what
the
I don't want
YouTube
to happen
drama
is she doesn't
sector that I'm trying to
verify
stay out of.
A video that's in possession of the Commonwealth is accurate. So what I don't want to happen is for her to see the video and just sign off on it without actually having to examine it ahead of time to determine its accuracy.
Judge, if I may.
You may.
The two things I need to say about this. One, the video I'm going to show consists of 3 clips that I intend to admit from a larger video that defense counsel received in discovery back in November. So it has been altered in the sense that I'm only showing the parts that I seek to admit into evidence. Also, it has been altered to mute the name of JT. But if we want to use the original, I have no objection to that. It's just longer and contains what I believe to be pretty irrelevant, but I wouldn't object to it. I'm happy to show it to her now, and we will see whether she recognizes it as being clips of the interview that she conducted.
And 3 clips. Are you able to give me a duration of each clip?
Because they are in one file,
If you can't, that's fine. I just know if you can.
the total duration of the 3 is, let me make sure before I say. 16 minutes and 36 seconds is the total duration.
Okay, thank you, Mr. Jenkins. Yes, Mr. Rogers?
Your Honor, Commonwealth has already admitted that the video has been altered. So with that admission, she can't authenticate it.
Are you kidding?
Commonwealth would say minor alterations. But Your Honor, I'm not comfortable with just presenting clips. She needs to authenticate the whole video, and if part of it comes in, I think I'll discuss it.
Okay. Do you have any authority for that position, Mr. Rogers? Because I'm unaware of the authority that, if she is able to say that this is an accurate, fair and accurate representation of the interview she conducted, what authority indicates that it can't be redacted to the relevant parts and that we cannot mute sensitive information such as the names of minors involved? What authority do you have for that that makes it inadmissible?
No, I don't have any authority regarding the muting or the name of a minor, but I'll just cite Baez versus Commonwealth. And I've got a copy of it before.
And regarding clips, 3 clips versus the entire video.
It doesn't directly address that. It doesn't.
Okay, but you're saying if they get parts, I want the whole one. How do you wish to do that?
Your Honor, I just, I'm going to object to just a part of it because of the reports of context. If some of it comes in,
And come up if they're not objecting to that. So what I'm asking you is, how do you want that? And well, let me back. Mr. Jenkins, how long is the entire interview?
Oh, I'll have to look at that.
That's what I'm asking Mr. Rogers. Are you asking him to play the entire interview?
Yes, ma'am.
Right?
Okay, that's what I want to know. How long is the interview?
Okay. So they're going to argue this for a few minutes.
So,
The end of the video, but what I believe is on here is in the date and time it was recorded.
Still arguing this.
Please, okay, proceed. Thank you.
So I'll resume playing the video from 15:30. I believe I've heard of those.
is that what you have to do? No, it should be
I believe. The video that I'm about to play is the video that the Commonwealth would seek to admit into evidence that has the 3 different clips.
I hit fast forward where I should have just let it play because I knew it was
So
coming
there
up.
was discussion about if the video was admitted, presenting the complete unredacted copy to the jury. Was that?
Is that still a defense request? And Commonwealth is in agreement with that?
Yes.
We're just talking about the parts that you all were not able to reach an agreement.
Okay.
Okay. Yes, sir, you may proceed.
Thank you, Judge.
All right. Here's some video.
Dr. Parker, thank you so much for joining me today. I'm here to first ask if you are giving permission for me to record this session to discuss the incident that occurred in Richmond on Friday. Yes. Okay. So
If I may, Judge, ask the witness, does what I've shown so far appear to be the interview that we've talked about?
Yes.
Okay. Judge, I can keep playing a little more, or I believe she's laid a foundation that this is the interview.
Mr. Rogers?
She's only seen my client's face. She clarified that I was just going to ask if, for purposes of medication. No way she can verify this. What's on the 16-minute clip is that what she has to see?
Ms. James, if you just jump to 2 other sections, if you're able to, and play about 10 seconds and ask the same questions.
Okay, I can.
Sorry. I'm seeing at the bottom of the screen a date and time stamp, and those are military hours. So those will move as you move your cursor?
Yes,
Okay.
Your Honor. So I can make a record of those.
Okay, and I didn't know if that's on video or if you have another cursor mark on your laptop that's showing the different time stamps.
So I have on the laptop, it is in absolute time, meaning 0 to the end of the video. But what I believe is on here is in the date and time it was recorded.
Okay, yes, please. Okay, proceed. Thank you.
So I'll resume playing the video from 15:38:28.
and he left. But those are the only 2. Okay. So help me understand.
And Dr. Ferris, does this still seem to be your interview with Dr. Parker?
Yes.
Okay, I'll jump forward a bit more. I've now jumped ahead to 15:47:26, and I'll play from there.
I was following her. So I said, okay, she called back, was not in school Thursday. And then when he came back Friday, those were the events of her. Okay. All right. So just to be clear.
And Dr. Farish, same question. Does this still appear to be portions of your interview with Dr. Parker?
Yes.
All right. Judge, with that, I think we've laid a sufficient foundation for authentication purposes in this video.
Yes, sir. Anything additional from the defense?
No, just to try to stress the whole point of authentication is to verify accuracy. Your Honor, it's the first time that she's going to see these clips as the Commonwealth has prepared them. We don't know what type of manipulation has occurred from. She didn't give this right to the Commonwealth. She gave it to other attorneys. We don't know what kind of manipulation occurred in the.
I'm trying to really be quiet and let this man talk. That's why I turned my camera off, because I know if my camera's on, I'm gonna go la, 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 and start talking. So I'm gonna turn my camera off. So I'll shut up. This is crazy because it's put together in clips. It's still the same people talking. It's still the same people saying the same thing. They just cut out some of the bullshit, like some of these people do on YouTube when they make clips and do clip channels. I mean, so long as you don't clip them in the wrong, well, okay, so maybe they could be clipped together wrong. I don't know. Right, Cindy? Lemon pound cake. I'm telling you. But and back to Journey. Journey was asking about this, the Millette, the Millette trial with the Maya Millette. And I wanted to stream that. I was so excited. I got all excited. I had it planned out. I had a thumbnail. I was ready to go with that trial. And then to find out that they weren't streaming it because of all the publicity and stuff like that. And they were like, no, we're not going to do it. There's just too much with the social media and everything. So, but I did find somebody on X that is following it and that is attending and doing breakdowns of each day. And so I figured at the end of the week, so maybe like a Saturday, Sunday stream I'll put together, and it'll just be just little excerpts of things from the news and some excerpts from things, so we can at least follow it, because it was an interesting situation, and we'll go over it when I do that. Yeah, a lot of people don't know the Millette case. So Millette, however y'all want to say it. So yeah, it'll be over the weekend, Cindy. I'll put it together, and it'll just be, because it's supposed to last like up to 3 months. And I was like, well, fuck, that's a long time, but I'm game, what else we got to do for 3 months but sit around here, right? And then I was like, okay, well, they're not streaming it, so we switched to this. So that's why we're here. But I figured if I could just do like a once a weekend update and put together just basics of what they did during the week and what was what was done. Yeah, it's been 5 years. It's been 5 years. And like I said, they're doing a lot of it's all kind of hush hush about the trial unless you're attending. And I have found somebody on Twitter that is taking notes of the trial. So we'll do that over the weekend. So, but anyways, back to this video. So we're trying to authenticate and say, yes, this is a video. It's not spliced. It's not cut. There's no manipulation in it. Blah, 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 blah. And I'm going to be quiet now.
Just showing her those very few seconds that she's not verifying the accuracy. She's verifying that essentially that's her talking to Dr. Parker. That's it. She's not verifying the accuracy of the contents of that video.
Yes. So again, the defense will continue to note their objection for the record. The court again is
we're in
going
the
to allow
same
this video to be played to the jury for the rulings it's previously made. But again, the defense section is noted.
May I please request to make a quick record related to that? Thank you.
But the court is also going to give a cautionary instruction to the witness. At any point when this is played, if you see something that is not accurate, please immediately say so we can address the matter. All right, thank you. Yes, Mr. Jenkins.
I just want to quickly, in response to, for the purposes of the record, Rule 2901, requirement of authentication. The requirement of authentication is satisfied by evidence sufficient to support a finding that the thing in question is what the proponent claims. So it is not about accuracy. It's about is what it claims. The arguments counsel has made about chain of custody and accuracy of the video, those go to weight, and he is free to make those arguments to the jury. They don't go to admissibility. Thank you for allowing me to do that, Judge. I think we're ready for the jury.
Sheriff, if you time to bring the jury out, and you ask all parties to stand while the jury comes out. If you're able, you're good.
Your Honor, I'm gonna step out in a second.
Okay, step out, Mr. Rush. Yes, sir. We'll wait till you come back.
Thank you.
Sorry, everybody, get your.
He's gonna stand out and stretch his knees. Y'all want the truth? He probably had to go potty. And he didn't want to say that, so he's gonna step out and stretch his knees. Stretch your knees, sir. We're gonna wait for you to come back. All right. Jury's here. Zoom, zoom. We get to the jury.
Hours, we're working on some motions to hopefully keep a swift pace through the day. As usual.
And this is the first time we've had the actual jury today. We are an hour and 15 minutes in, and we're just now seeing the jury.
Try to break around 1 and try to
Oh, jolly today.
for evidence for the day. And if you need any breaks, let me know. Now, I haven't asked the parties, the juror box as a whole, but we had that cautionary instruction not to research this case outside of what's presented to you in the courtroom, not to discuss it with others, and if somebody approaches you, to inform the court. Does anyone wish to report any potential misconduct or issues? Okay, and there is nothing being said, and for the record purposes, parties are shaking their head in the negative. And again, I'll give another cautionary instruction, again, amongst yourselves. Please do not discuss the case or ask questions until this case is given to you for deliberation. That's a specific legal moment and legal procedure. So you can talk about the weather, talk about family, but just don't talk about the case or questions amongst yourselves until the case is given to you for deliberations in that moment. Okay, with that being said, we are going to proceed with evidence today. The witness has already been sworn in, and the Commonwealth will start the direct examination. Mr. Jenkins.
Thank you, Your Honor. Good morning again.
Good morning.
Would you please tell us your name and how you're employed?
Nina Parrish, Human Resources Director for Newport News Public Schools.
And Dr. Parrish, how long have you been in that role?
For 4 going on 5 years.
And so were you in that role on January 6, 2023, and in the month of January 2023?
Yes.
Do you know someone named Dr. Ebony Parker?
Yes.
And was she employed by the school system?
Yes.
How so?
As an assistant principal.
Okay. And is she in the courtroom right now?
Yes.
Could you please point her out?
Yes.
And Judge, I'd ask the record to reflect that she's identified the defendant.
So noted.
After, did you become aware of an incident occurring at Ridge Neck Elementary on January 6, 2023?
Yes.
And after that incident, were you called upon to investigate it?
Yes.
Generally, what was the nature of the incident you were told to investigate?
A student shooting at Ridge Neck Elementary School.
Understood. As part of your investigation, did you conduct interviews with many people?
Yes.
Did you conduct an interview with Dr. Ebony Parker?
Yes.
And technically, how was the interview done?
Via Zoom recorded.
Okay. If I were to show you different clips that have been edited of that interview, would you be able to recognize those clips as being the interview that you did?
Yes.
Okay. Judge, with the court's permission, I'll publish this to the jury and indicate as well that this is 3 clips from a larger video that we will enter into evidence as well, and that the audio on this has been muted wherever a child's name was spoken. May I publish to the jury?
You may, and for the jury, defense has objected, and of course allowed that the video will be played. I don't think it requires their name, but do either of the attorneys want the courtroom to be dimmed?
Not necessarily.
Okay, you may proceed.
Okay. So Dr. Parker,
Dim the
thank
light.
you so much for joining me today. I am here to first ask if you are giving permission for me to record this session to discuss the incident that occurred at Ridge Neck on Friday.
Yes.
Okay. So as part of our internal investigation, I have some questions for you. I do ask that you please answer questions honestly. I also ask that you please keep our investigative conversation confidential so that to maintain the integrity of the investigation, because I do have several people I need to speak with. Okay? Okay. So, Dr. Parker, let's start with Friday. Were you given any knowledge prior to the actual shooting that the student had a weapon?
I was told that this students reported that the student had a weapon in his backpack. So, Miss Kodak, what about these names?
Yes, ma'am, please.
Okay, so Miss Kodak is the one who informed me of this. And she said that she had already asked the student, is there something in your backpack? And he said no, but she had brought it to me. The class was about to go outside to recess. So I said, well, when they go outside to recess, we can check his backpack. I was in the midst of the winter road assessment, printing off tickets and stuff. So I didn't go into the classroom with her. When she came back, she says, there's nothing, I didn't see anything in his backpack. And I said, okay. And she said, but, what about in his pocket? And I said, well, I don't know. Are they going out to recess? She said, yes. She was also my person that was helping me with testing. So, I don't know if she went outside or not, but there was a comment that said, well, we watched him closely.
I have a question. I'm raising my hand because I have a question in my own stream. I looked back at my notes because y'all know I'm a note taker. This incident happened on January 6th. The date on that's January 9th. Y'all waited 3 days to do a sit-down interview with her? Really? Oh.
Assuming she meant herself and the teacher. And I said, okay. And then I went on with testing.
So was all of that conversation from Ms. Kovac all at the same time, or did she come back to you with the comment about we watching him?
She came back.
Okay. So, do you remember approximately what time it was when she reported to you, the students reported that he had a weapon?
They were going outside for recess at 12:20, so it was right before that. So I don't know how far between it, but I know from the time that she said it to the time that they went outside for recess, it wasn't very long.
Okay. Did you report this to Ms. Foster?
I did not. She was in a meeting with a military counselor that we were supposed to be getting, and I was supposed to be going into that meeting at 1. That was the meeting was at 1, and I didn't make it into that meeting. But because I was in the midst of testing, I don't leave my office when we're in testing to maintain the testing tickets and the security of that. And so I had not spoken with Ms. Austin.
Okay. So can you tell me, did anyone else come to you before the shooting to tell you that the student had a weapon?
So after we checked his backpack and there was nothing there.
And you say we?
Well, I say we because I said check it. So, but Ms. Kovac went in to check it.
Okay.
Yes.
Okay.
But I said we because she came to me to ask, should we check his backpack? Do we check his backpack? Mr. Ross, after that situation was settled, came back into my office and he said, hey, did you hear what they said about? I said, yeah, I heard. I said, but we checked his backpack.
I mean, I'm just totally confused here. I just would have thought that we would have been watching a police interrogation video before any of this human resource that's 3 days later. I mean, I may be totally out of line here. I'm just thinking, we doing this out of order? What? It was just weird to me. I guess it's in order of the people they're bringing up. Maybe we'll get to the police officers and they're going to have video. Because you remember yesterday they were talking about body cam video. So okay. I'm going to be quiet and just hit play because I'm confused now.
Again, I'm still using we, but it was Miss Kovac. I said, his backpack was checked, we didn't see anything. And he says, oh, okay, did you check the person? And I said, oh, no, we didn't. And I remember looking at the clock and it was 1:40. And this particular student is on a modified schedule. So I said, his mom is due to come here soon. So when his mom comes, we need to inform her of what was said, what we did, and then she can, we'll let her go through the rest of his things and check it. He nodded his head and he left. But those are the only two.
Okay. So help me understand, what is your understanding of what should have taken place from the first notification that you received about the student from Ms. Kovac possibly having a weapon?
What we did in previous times before, we had two other students who also were reported to have a weapon. And we, asked the student, if you have something that say, no, we do have someone else come in with us to look in a backpack. But we never searched a student. So because Ms. Clark didn't see anything in the backpack, then we didn't do anything from there. His mother does come in every day, and we have a conversation every day. So I was waiting for mom to come in.
So in the past phone calls of what you've done, and correct me if I'm wrong, you've brought the student into your office, and you, along with who else?
So the first time it was Mr. Rawls, and then the second time it was an incident of a parent had already called the police because the report was given to her from her son, so she had already called the police. So the second time it was the police was at the school.
Okay, all right. Had Mrs. Zwerner on that Friday come to you and express concern about the student's behavior, or did she express that she thought the student had a weapon?
No. So Ms. Zwerner never said that she thought that the student had a weapon, and she never said to me directly that it was reported to her that the student had a weapon. So I was about to get the PM session of the testing started, and she came into my office and she said, is being extremely defiant today. And she says, if he hits me, I don't know what I'm going to do. So I acknowledged what she said, and I said, oh, okay. And then she left. So I told Ms. Kovac, because they didn't want to go down as the kids, I said, if she feels that he's being, uncontrollable, she can't control him, tell her to call his mother so she can come and pick him up early, is what I said. But no, Ms. Zwerner never came to me and said anything about her fearing that the student had a weapon or that she felt unsafe. She didn't say that to me.
Okay, all right, take your time. Had Ms. Zwerner, prior to Friday, ever expressed to you that she had concerns or felt unsafe with this particular student?
No, so it has been on a monitored schedule since the beginning of the year. His acting out was he's extremely defiant, and he does the exact opposite of what he's asked to do. And it was making it difficult for her to do instruction.
She's already explaining right here, he's a very defiant child. Yeah, why wasn't the mother called right away? I'm
in the classroom. So we sat down and we made a modified schedule. We had things in place. So somebody was getting the bus. He was going to Miss McBurnett's room to do a social story. He was then transitioned to Miss Kovac for a 15-20 minute small group session before he spent time in his classroom. And Wednesday, he had asked to come to the office, and he said no. Ms. Zwerner said no, he couldn't come to the office. And he took her phone and threw it down. So it cracked her screen.
Wait, he asked to come. I know, and I got ball cheese in my mouth. I'm sorry. He asked to come to the office and threw her phone down. And wait. Let her re-explain that, because this goes to that Wednesday before, because remember Thursday he didn't come to school And Friday is when the shooting happened. So I need to hear this. I need to hear this again. Yeah, I know. Southern, I know.
He was then transitioned to Ms. Kovac for a 15-20 minute small group session before he spent time in his classroom. And Wednesday, he had asked to come to the office, and he said no. Ms. Zwerner said no, he couldn't come to the office. And he took her phone and threw it down. So it cracked her screen. Ms. Foster and myself, I sat in the meeting, but Ms. Foster had, facilitated the meeting that afternoon with Ms. We told, hey, no damage that it is to the teacher's phone. We'll let you know. She understood that she was prepared to pay for it and everything. So, in hindsight, that evening, I spoke with Ms. Foster, and she said, I really think I'm going to call his mom back because he should have gotten a consequence for what he did. And I said, well, yeah, but, I was following her. So I said, okay, she called back, was not in school Thursday. And then when he came back Friday, those were the events of Friday.
Okay, all right. So just to be clear, at any point in time prior to Friday, did Ms. Zwerner ever report to you that she had concerns about the student or about her safety with that student?
No. The concerns were around the student and his behavior. Never has she said, I feel unsafe.
So when she made the statement to you, if he hits me, I don't know what I'm going to do. Can you tell me where that came from?
So that Wednesday, where I feel it came from was that Wednesday when he took her phone and threw it down, he went to a buddy classroom, which was Ms. West. And what Ms. West reported to Ms. Newton was that he was pinching at her, but I did not get I didn't get the full report of that incident. So when she said that, me knowing that was what was reported Wednesday, that's where I think that came from.
Okay. Was there ever a comment made to the teacher that she was overreacting to the student or his behavior?
No.
Okay. Prior to Friday, had anyone, Ms. Zwerner or anyone reported to you their concerns about the student or about their safety or possible safety of others in the building because of that student? Okay. So staff stating that administration knew, what is your response?
Could we pause?
Yes, you can pause. Yes, sir.
Just a moment to talk to the council, then I think I have an objection.
A brief moment.
There's a lot of, I'll say hearsay statements that are being propounded by Ms. Sayers, things that other people may have said. And so I understand videos is coming in, and it should come in regarding my client's statements. But any statements made by Ms. Sayers, I would submit to the court about who's over hearsay. Any statements that she is alleging was made or declared by another party, I would submit this hearsay, and I would ask the court to instruct the jury not to consider statements of Ms. Sayers or what somebody else may have said, but only consider my client's responses to those questions.
Judge, I would ask that we continue playing the video for now and make a decision about whether there needs to be some sort of curative instruction after that.
So I will, again, continue to play the video, but I will grant a defense motion that will give a curative instruction So prepare that, when it's time for instructions, of whose testimony they can consider in this video, and the hearsay. All right, you may proceed, Mr. James.
I don't know.
Judge, may I back up just a little bit to give context?
Yes, sir.
I'm going to start back at 15 hours, 50 minutes, and 0 seconds.
Yes, sir.
Administration knew. What is your response to that?
I don't know. I don't know because what I did and what we did in the moment with how to support with him is what I thought the teachers, Ms. Warner, was asking for. Like, just, I can't get instruction done. He doesn't sit down in his space. He won't follow directions. Those were the things that Ms. Warner was reporting to me.
Okay. I want to go back real quick because I want to make sure I'm clear on something. Ms. Kovac, check the bag. What is Ms. Kovac's title?
She's our reading specialist.
So help me understand why Ms. Kovac why did you direct Ms. Kovac to check the bag? So,
in the midst of testing, I don't remove myself from the office. And when the conversation we had was, should we check his bag? And the reason why we waited till they went out to recess is because I couldn't leave to go and check the bag. So it was my director that said, Ms. Kovac, when they go out to recess, check his bag.
Okay.
That's, God, I hate, again, we go back to the mental health and all that stuff. There's something so much more going on. I just want to be quiet and let her talk, but I got to pause. I have to pause. You're right. That's messed up. Hurry back, Cindy. We're pausing and talking for a second. Oh my goodness. Okay. All right, I'm gonna hit play because I know Cindy knows how to hit that 2x speed, and I don't. She can do it. All right, I'm gonna go back to hit play. Back up just a couple seconds.
Till they went out to recess office, and when the conversation we had was, should we check his bag? And the reason why we waited till they went out to recess is because I couldn't leave to go and check the bag. So it was my director that said, Ms. Kovac, when they go out to recess, check his bag.
Okay. Did you talk to your resource officer that day?
She was not there.
Okay.
Oh, the resource officer, the actual, I didn't call, I didn't call. And our security officer, Ms. Lee, she leaves every day at 2:00.
She leaves at 2, so Ms. Lee.
I'm sorry, not 2:00, 12:00. And she comes back after McIntosh's dismissal, for our dismissal. So she's with us in the morning from 9 to 12. I'm sorry.
Okay. Okay. All right.
Dr. Parrish, was what you just watched a fair and accurate depiction of some clips of a longer interview that you did with Dr. Parker?
Yes.
Judge, at this time, I would seek to admit into evidence a USB thumb drive and an envelope labeled HR Interview Parker that contains the clips that have just been shown to the jury. I would move to enter that as Commonwealth's 2.
So introduced over defense's previous objections, which were made, considering being marked as Commonwealth 2.
And Judge, at some point, I will need to take a moment to get the full and complete video saved to a drive, and at that time, I will move the full video into evidence as well so that the jury will have access to it.
Yes, sir. Any additional questions for this witness from the Commonwealth?
Yes, Your Honor. Dr. Parrish, Do you serve as a custodian of records for the purpose of providing things pursuant to a subpoena?
Yes,
And you do that for the school district?
yes, sir.
Okay. And I want to direct your attention to any publications that the district makes that are official. Is there a rights and responsibilities handbook?
Yes,
And is there one in particular that contains a student code of conduct and also is for the year that was applicable, the 2022-23 school year?
yes,
Do you have that document with you today on the stand?
I did.
Would you mind pulling it out? And did you bring that with you today?
Yes.
Okay. I'd like to direct your attention to that document. And specifically, if you would look on page 28 of that document, let me know when you're there.
I'm there.
I'm going to just direct your attention to a paragraph that begins principals and school. Do you see that paragraph?
Yes.
I'd like to ask you to read just that paragraph into the record, please.
Principals and school security officers, under the direction of a school administrator, may search students and student property, including automobiles and other vehicles.
Okay.
Hold on a moment. Yes, what's the objection?
Dr. Foundation, Your Honor. Ms. Ferris is not the author of this document. She has not established that she has authored it or was otherwise familiar with it. She testifies that she responds to subpoenas and things of that nature, but she has not made that the proper foundation has not been made.
How much?
The court has already ruled on that. It is
We ruled on hearsay, we didn't rule on foundation.
Okay. Well, she has testified that on hearsay, we had a ruling that this was a public record. She testified that she is the custodian of records and that what she's reading from is in fact an authentic record of the Newport News Public Schools. She brought it with her here today herself and that it was in effect on the time in question. So that's all the foundation that is needed for her to tell us the content of that document. It is admissible.
The court rules the proper foundation has been laid. If you would repeat your question of what you asked her to read.
Yes, Your Honor. So thank you, Dr. Ferris. This is page 28, a paragraph that begins principals and school security officers. Could you read that paragraph, please?
Yes. Principals and school security officers, under the direction of a school administrator, may search students and student property, including automobiles and other vehicles, when there is reasonable suspicion to do so. Students should understand that they have no expectation of privacy to their lockers, personal property, or vehicles allowed to park on school property. Consistent with applicable legal requirements, school division personnel may use search techniques such as metal detectors and use other lawful search techniques.
Thank you. I want to ask you now about a different document. Does the public school system require individual schools within the district to create a multi-hazard crisis and emergency management plan?
Yes.
And during the course of your work, if such a plan is subpoenaed in litigation, are you the custodian of records that would provide it?
Yes.
Do you have with you, or have you brought with you to court here today, the Rich Neck Elementary Multi-Hazard Crisis and Emergency Management Plan for the 2022-23 school year?
Yes.
And is what you have here today with you a fair and accurate copy of that plan?
Yes.
Okay, please give me just a moment. I'd like to direct your attention to page 18.
Your Honor, I'm going to request some what they're on her foundation of knowledge regarding this particular document.
Okay.
If the voir dire is going to admissibility and it's going to be allowed, we will have to remove the jury from the room because admissibility is not a factor for them.
Yes, sir.
And what's the basis for this again?
I don't think the proper foundation has been laid regarding her familiarity with this document itself. Again, he says that she responds to subpoenas and produces it in response to subpoenas. That does not mean that she has familiarity with the document, knowledge of who created it, or anything of that nature.
So I'm not going to allow this to one here at this point. Mr. Jenkins, can you try to lay a better foundation?
Okay, Dr. Ferris, let's back up. is the multi-hazard crisis plan for 2022, 2023 required by law to be created by the schools?
That is my understanding.
Okay. And are the plans records of the schools?
Yes,
Official records?
yes,
Okay. And is what you've brought here today an official record of the school that was in effect at Rich Neck on 2022, 2023 school year?
yes.
That's that.
Foundation established and received objections overruled.
So I'll direct your attention to page 18. Do you see the heading that begins imminent warning signs?
Yes,
18. And also, I want you to just look over to page 19. Do you see the heading that says mitigation?
yes,
I am going to ask you to read everything between those 2 points, stopping before the mitigation heading.
okay.
And also, the court reporter is writing this down, so if you could read relatively slowly to make sure.
I'm sorry, I need to let
10 seconds.
I'll provide it, Judge.
Thank you. All right, you may proceed.
Unlike early warning signs, imminent warning signs indicate that a student is very close to behaving in a way that is potentially dangerous to self and/or to others. Imminent warning signs require an immediate response. No single warning sign can predict that a dangerous act will occur. Rather, imminent warning signs usually are presented as a sequence of overt, serious, hostile behaviors or threats directed at peers, staff, or other individuals. Usually, imminent warning signs are evident to more than one staff member, as well as to the child's family. Imminent warning signs may include serious physical fighting with peers or family members, severe destruction of property, severe rage for seemingly minor reasons, detailed threats of lethal violence, inappropriate possession and/or use of firearms and other weapons, other self-injurious behaviors or threats of suicide. When warning signs indicate that danger is imminent, safety must always be the first and foremost consideration. Parents should be informed.
You know what? Just because we're going to rewind this because I feel like I need to pay better attention. Oh, we have a visitor too. Hold up.
Detailed threat.
Hold up. We have a visitor. It's visitor time, guys. It's visitor time. Hold up. Y'all know we have to take a break. It's visitor time. We knew this was going to happen. We had the cheese balls ready. We had the cheese tacks. Okay. Everybody, it's Lola moment. Okay. Cheese tacks time. And we're going to jump right back to trial. One more cheese ball. Okay, go. Okay, back to trial. Hit that button back.
Of lethal violence, inappropriate possession and/or use of firearms and other weapons, other self-injurious behaviors or threats of suicide. When warning signs indicate that danger is imminent, safety must always be the first and foremost consideration.
When the warning signs indicate danger is imminent,
safety must always be the first and foremost consideration. Okay. Parents should be informed of the concerns immediately. School communities also have the responsibility to seek assistance from appropriate agencies.
It was earlier.
Such as.
Girl, I will back.
And is what you have here to.
I will back this shit up. You know me. I ain't even. I got all night. I'm
going to request some while you're on this document.
We will have.
Let her read that whole damn thing again.
22.
Because I'm not gonna lie, I was a little squirreled because let's just say we all know Hio. We're all know who HEO is and True Crime Guardians, and I just want to let everybody know that as a person in the community, she's very special to me, and everybody needs to keep her in your thoughts right now. She needs that extra love. She needs that extra love. So let's do that. And that's why I was kind of squirreled for a moment. So
2023 required and brought here today, school year, is imminent warning. Do you see the heading? So the court.
Okay, she's going to read it.
Thank you. All right.
So that's why I was multitasking. So
Unlike early warning signs,
So if you have it in your heart and you're that type of person, lift her up, keep her in your heart, keep her in your mind. She needs that right now. So she's a beautiful person.
imminent warning signs indicate that a student is very close to behaving in a way that is potentially dangerous to self and or to others. Imminent warning signs require an immediate response. No single warning sign can predict that a dangerous act will occur. Rather, imminent warning signs usually are presented as a sequence of overt, serious, hostile behaviors or threats directed at peers, staff, or other individuals. Usually, imminent warning signs are evident to more than one staff member, as well as to the child's family.
Oh,
imminent
sorry.
warning
I didn't mean to do that. I meant to rewind her because
peers, staff, or other individuals. Usually, imminent warning signs are evident to more than one staff member, as well as to the child's family. Imminent warning signs may include serious physical fighting with peers or family members, severe destruction of property, severe rage for seemingly minor reasons, detailed threats of lethal violence, inappropriate possession and or use of firearms and other weapons,
inappropriate use. What?
detailed threats of lethal violence, inappropriate possession and or use of firearms and other weapons, other self-injurious behaviors or threats of suicide. When warning signs indicate that danger is imminent, safety must always be the first and foremost consideration. Parents should be informed of the concerns immediately.
Okay.
School communities also have the responsibility to seek assistance from appropriate agencies, such as Child and Family Services and Community Mental Health. Immediate intervention by school authorities and law enforcement officers is needed when a child has presented a detailed plan, time, place, method to harm or kill others, particularly if the child has a history of aggression or has attempted to carry out threats in the past. Is carrying a weapon, particularly a firearm, or has threatened to use one, or exhibits other threatening behaviors.
Thank you, Dr. Ferris. I'm going to direct your attention to just one more section of that same document. We're just going to page 60. And on page 60, do you see the heading weapons threat?
Yes.
I'm just going to ask you to read.
Absolutely, Teresa. So now they're going to read something else, a weapons threat, which I'm totally like, I'm listening to this and I'm like, okay, all right. Okay.
Read only that section that falls under the heading weapons threat.
If a student or other person makes a threat with or about a weapon, gun, knife, or other weapon. Evacuate the area. Evaluate the perpetrator, evaluate the perpetrator. Isolate, consider lockdown, notify law enforcement, remain calm, get help, avoid heroics, do not threaten, keep a safe, non-intimidating distance.
Okay, so far, I'm gonna rewind this because I want to hear this again. I'm like, this is evacuate the air.
I'm just going to ask you to read only that section that falls under the heading weapons threat.
If a student or other person makes a threat with or about a weapon, gun, knife, or other weapon, evacuate the area. Evaluate the perpetrator, evaluate the perpetrator. Isolate, consider lockdown, notify law enforcement, remain calm, get help, avoid heroics, do not threaten, keep a safe, non-intimidating distance, avoid abrupt, sporadic movements, look for an escape route.
Thank you, Dr. Ferris. That's all the questions that I have for you. Please answer any questions from defense counsel.
Oh, they're gonna tear up. They're okay. Pause for commentary because it's what we have to do. I have a feeling. Ooh, look, break your mic, Sheila. I have a feeling he's fixing a ripper. I just have a feeling this isn't going to, like I said, some of this, I preview a little bit of it, but I don't watch it. And I don't know what's going to happen, but I have a feeling this is not going to go very well. Yeah, only consider a lockdown. Consider. And we're sending some 100% love. All right. Okay. Whew. Okay, here we go. Defense side of this. Ready? Buckle in, y'all. I might turn my camera off because I might have to smoke a minute. Whew. We don't need duct tape. We have squishy ducks. Sorry, I'm gonna lose my shit with my squishy ducks.
Still morning. Good morning again.
Broken neck.
All right, a lot to unpack. So
a lot to unpack.
Over,
duck butt.
Again, you
duck
are
butt.
the HR director for Newport News Public Schools, and you conducted an independent investigation of this whole incident. Is that correct?
That is correct.
Okay. And in your investigation of this whole incident, did you have access to the videos from school property or any other videos?
Objection. This goes beyond the scope of the direct exam, and is also asking about the investigation and other things that I didn't go into. It didn't show.
It wasn't elicited on direct. That's one of the first things that she testified to. That was her responsibility to do a complete investigation of this incident.
Okay, and that was one part of your question, but there were other parts. So I'm trying to figure out where the scope of objection lies.
So I'm asking her about how she conducted the investigation. I think it's a fair question, though.
And what's wrong?
Sir, and let's work on the compound questions because I notice this man does a lot of compound questions. I mean, we ask one question, we elicit the answer, and then we move on. Let's not ask 3 questions in one sentence. Okay.
What's your scope of objection towards?
The concern, Judge, is getting into the findings of the investigation, but as to did she conduct an investigation and what did she observe in the investigation, I wouldn't have an objection to that.
I hadn't gotten to the point where I was asking for a conclusion at all.
All right, okay. But if you plan to get there, I think you're going to object.
Well, we'll see what happens as we go along.
All right, you may proceed.
Okay. So you did conduct a complete investigation of this from the beginning of the incident to the end. Is that correct?
Correct.
Okay. And as a part of your investigation, did you do the videos that may have been produced on Newport News School System's surveillance cameras?
Yes.
Okay. Did you also look at videos that may have been produced by Newport News Police Department?
Not by the police department, no.
Okay. So could you describe how many different positions video cameras are placed at Rich Neck Elementary School?
You want me to describe, you're not asking how many.
I'm asking you how many different positions, sir? Is it?
I don't recall how many.
Okay, well, let me ask you a different question. Would you say that you could pretty much, through this video surveillance, monitor most of the activities that occurred at Rich Neck Elementary School?
Most, yes.
Okay. Were you able to see what things occurred in the hallways?
Yes.
Objection, Judge. We're getting into the content of things that he's not planning to show. He should be required to produce those videos if he's going to ask her about those videos.
I don't think I'm required to show anything. She's testifying. She's producing evidence. I don't have to cooperate that by video.
And what objection is this? What legal principle is invoked here?
Lack of foundation.
Your response.
Your Honor, she's testifying as to what she observed. So, she looked at videos. She says. Of what she observed on these videos. So I'm not asking to introduce these videos. I'm just asking her what she observed on these videos.
And are you going to ask her to describe what she observed on the videos?
She is probably. I'm going to ask her to summarize what she saw in these videos. Yes.
How is that admissible?
How is it admissible? It's something that she observed. I mean, she can testify as to what she observed.
Okay, so that goes back to his objection. Why isn't the best evidence rule implicated at that point, or other evidentiary rules? I guess what authority exists to allow her to testify as to what she observed in the video without the actual video? And is this video admissible in and of itself? So if this video is not admissible, how can she testify as to what she saw on video? How would that also be, by analogy, admissible?
No. Obviously, we have already submitted video into evidence.
Well, one video. Are you talking about that video or a different video?
No. I'm talking about the surveillance video, and I think the court and even the Commonwealth is well aware that videos are considered to be silent witnesses of whatever events that they record.
It wasn't Lola, but you know what? Just because I have to, and because Cindy's got me thinking about nachos.
Nacho man, yeah. I've got to be a nacho man. Got to be a nacho.
If I had the videos, I can. I guess I can ask the court to take a recess so I can show her several.
Y'all
videos
got me all over the place today.
2 questions, or I guess one more. Yes,
I like this judge too.
What she saw on the video. Second, are you asking to introduce evidence in the Commonwealth's case in chief?
Obviously, evidence is coming into the Commonwealth's case in chief.
I say, is the defense asking to introduce defense evidence in the Commonwealth's case in chief?
Not at this particular time, other than the testimony.
Are y'all getting what he's throwing down? Are y'all picking up? Are you picking up what he's throwing down? This dude, okay, you got me thinking about nachos now. See, and I was thinking about ordering something from Chili's at one of the triple dipper appetizer thing. But now y'all got me. Now I got nachos over. Okay, but look, y'all understand what this guy is doing. Okay, hang on. Let me make this thing rewind. He's trying to bring in evidence into the Commonwealth's case, not his defense, but it's for the state. Shh, dude, you're working on the wrong side.
Second, are you asking to introduce evidence in the Commonwealth's case in chief?
Obviously, evidence is coming into the Commonwealth's case in chief.
I say, is the defense asking to introduce defense evidence in the Commonwealth's case in chief?
Not at this particular time, other than the testimony, Your Honor.
Okay, so again, my ruling is that she did not testify as to what she observed on the video. I sustain the Commonwealth's objection. Next question.
Okay, so I'll continue to ask the questions, and then the Commonwealth can object and the court can rule.
Yes, sir. And again, to the attorneys, I know there have been a lot of objections, and there were a lot of objections yesterday, and squirrels all over, and sometimes I might be grumpy, but I'm
She
not
said
grumpy with
squirrels!
attorneys, and they are doing their job, so don't hold that against them. That would cost you.
I'm panicking. The judge said squirrels. Did the judge say squirrels all over? Please tell me That's what I am mishearing things, y'all. I'm listening to the dogs playing, and I'm ready for y'all to make a comment about all that thing going over here. And I'm like, okay, did this judge just use the word squirrel? No, he didn't like that at all, Cindy, but I swear she used the word squirrel. Hey, Vibe, how you doing? Okay, I'm gonna hit play, and I swear if this judge said squirrel, I'm gonna have to clip it.
A lot of objections, and there were a lot of objections yesterday. Squirrels all over, and sometimes I might be grumpy.
She did! She said squirrels all over!
They're doing their job, so don't hold that against them. That was a cautionary instruction in the beginning. It is their duty to look at, to make sure the rules are followed, and we analyze the rules of evidence. Okay, you may proceed, Ms. Rogers.
Okay. Other than Dr. Parker, were you able to determine the conduct of any other employees that were at Rich Neck Elementary on January 6th?
Okay, don't answer. So your question was, she able to
observe the conduct behavior of other parties, other staff members at Rich Neck Elementary School?
Okay, and your reference to this incident?
Yes, ma'am.
Okay, and your objection is what, Mr. Jenkins?
Authentication that she's testifying to that, what she would have seen on a video. She wasn't there. She can't authenticate the video, and she can't describe a video that counsel's not producing. It's the same objection.
Your Honor, if I don't have the videos to produce right now, so she conducted an independent investigation. Obviously, she observed a lot of things by video. If the court believes that she should not be able to testify as to what she observed by video, then I'll prohibit it.
So I sustain the objection because it's the same thing we just discussed. Right. Again, if it can't come in through the front door, it cannot come in through the back door. Next question.
And they're doing this in front of the jury, guys. Yeah, the prosecutor, he's on. He knows what he's doing.
All right, let's
the jury's there.
Go to the let me first talk about you being a custodian of records. Have you testified as a custodian of records for News Public Schools previously?
Yes.
Okay, and so you're the custodian of this document, is that correct?
Correct.
Okay. All right. If you'll turn to page 17 of this document.
Yes, sir.
Okay, it talks, I guess, about halfway down. It says teacher removal of a student from class.
Yes.
Actually, let me start at the very top. It says disruptive.
Okay, I tell y'all, he's going to try to tear her up. He's going to try to tear her up. And Vibe, I'm so glad you stopped by. It's so good to see you. I know I haven't seen you a whole lot on the streets lately. In case you haven't noticed, Rubber Ramada has gone strictly pretty much back to her true crime. Well, not strictly, but not pretty much, but strictly. You won't be seeing me on the streets anymore. I will be here in my true crime genre, doing my true crime thring with the duck butt. Okay. And yeah, so if you know anybody that's interested in true crime and wants to watch trials or anything like that, that's only going to be true crime related, no drama, no crama, no nothing like that. Hey, shout me out, share the stream, like the stream if you haven't. Thank you for joining the duck pond and hanging around. We are almost to a point of where I might be able to get monetized and we can have cool ass emojis. I need some crazy squirrels. I need some duck butts over here. So anyways, if you don't mind, share it out, like, subscribe if you haven't. And look, I got my sea mastiff over there in my cake throwing them duck butts up. Duck butts and some meat. Yeah. We do some chase videos too. I try to hide some of those. Girl, I've seen some crazy chase videos lately. But anyways, back to trial. And I just wanted to tell you that thank you for being here, Vibe. It's been a minute since I've seen you.
Students in the classroom. Could you read that first paragraph, please?
He's going to tear her up.
The disruptive students?
Yes, ma'am.
The code 22.1-276.2 provides statutory guidance related to the initial authority of a teacher to remove a student from class for disruptive behavior. The code 22.1-276.01 defines disruptive behavior as a violation of school board regulations governing student conduct that interprets or obstructs the learning environment. The provisions set out below are supplementary to and are not intended to replace the authority of a teacher or administrator to discipline students according to rules described in this handbook. It is the school board's intent that the process of working with students and parents to be focused on seeking solutions to eliminate disruptive behavior in order to improve student achievement and student citizenship.
Okay, so would you agree that this paragraph, which cites Virginia Code 22.1-276.2, gives a teacher the authority to remove a disruptive student from her classroom?
Objection, that's improper opinion testimony. She's not been qualified as an expert to answer that.
Response.
Your Honor, she is here as an agent of the Newport News public school system. She can advise whether or not she believes that Virginia Code allows a student to be removed by the teacher. It spells it out pretty clearly there, but I just want her to verify.
Just rephrase it. I think you can rephrase it as to not to what her opinion is, but as to what's in the manual.
Does this manual, which cites Virginia Code, give a teacher the authority to remove a student from the classroom?
Yes.
Regarding your investigation, was JT ever removed from the classroom?
Objection, Judge, this is getting into the findings of her investigation now, which is the province of the jury to decide.
And your response.
Your Honor, I'll submit that to you. I'm not asking for a finding. I'm not asking for a conclusion. I'm asking for a fact. I ask her to determine if something actually occurred or did not occur. It's not a finding.
Okay. So again, legal conclusions are a problem for the jury, but how is the finding of this school investigation not come, well, how is that not relevant and admissible?
Judge, the investigation is findings of fact that lead to a legal conclusion. And we have a jury who are the fact finders for this trial. So any findings of fact that are based on her investigation are the province of the jury. And beyond that, Judge, this is beyond the scope of my direct. I did not ask Dr. Barish opinions or ask her to give any conclusion about any aspect of her actual investigation, because that's the province of the jury.
I'm going to allow it in over the Commonwealth's objection. The court's rationale is the Commonwealth has introduced the school handbook, the policies and procedures, and the crisis management. And there's been a lot of evidence and questions towards was that followed on that day. So that's a proper subject for cross-examination. And what the school found and all the school policies can come into evidence. We can have a curative instruction later if parties want that the school findings are not legal findings and legal conclusions for this case. And that is for the fact finders. And that is to the criminal charge of child abuse and neglect and endangerment, not to whether or not the school procedures were followed. So that finding of that investigation is not a legal conclusion. So if that's the court's basis, I'm going to allow it in. You may proceed, Mr. Rogers.
Thank you. Ms. Kovac, if she was having some problems with JT, if he was being disruptive, there was nothing that prevented her from removing him from the classroom. Is that correct?
Correct.
Okay. Are you familiar with Ms. I think I mentioned the name Kovac. I meant Zwerner. I meant Zwerner. Could you answer the question in regards to Mrs. Zwerner? She could have removed JT from the classroom. Is that correct?
Correct.
Okay. And if Ms. Kovac had contact with JT and thought that he was being disruptive, she could have removed him from the classroom. Is that correct?
Correct.
Okay. If Ms. West had some contact with JT on the playground as a teacher, she could have removed him from the playground. Is that correct?
Correct.
All right. So regarding
They're really,
multi-hazard.
they are really, really showing like everybody's failure in this. I mean, it could have been done so many different ways. Hey. Oh, sorry, it's you, Ty. I sorry. I thought it was the dogs. Sorry, son. I'm over here hollering at son. I thought it was the dog staring up something on the table, and he's over there with the black swatter hitting things. Oh, whew, sorry about that. Anyways, I don't even know what I was saying. I just totally squirreled. What was I saying? These dogs. No, go away. I'm going to hit play because I don't even know what I was saying. I got squirreled with that.
Crisis and emergency management plan.
Oh, what I was saying is it seems like everybody could have, should have, maybe would have, but didn't do something. So it's just, this, and I really went in here. I prejudged, and then I was like, nope, we're gonna go in here with a clear mind, and we're just gonna listen to everything. And now that I'm listening to everything, I'm like, yeah, right, Cindy. And they tried to name the other ones. There was 3 other ones, and no, baby, and they were removed from the civil case, and now it's just this one principal. I'm just like, I'm not sure how this is gonna go. I went in here like I said at first with a preconceived notion of she's guilty. Hannah Banana LWAP, but I there's so many other people that I feel kind of failed in a way. I don't even really, like I said, I'm gonna hear everything out before I judge.
This is a plan for each individual school, is that correct?
Correct.
Okay. And are you, who's responsible for producing this document, if you know?
That would come under our safety security department.
Okay. Prior to this incident happening, were you familiar with this document?
I know that the schools have them, if you're asking if I'm familiar with this particular one prior to that incident, no.
Okay. And so you have become familiar with this document since this incident has occurred, is that correct?
Correct. And when you say familiar, again, custodian of records, it was presented to me. I was not the writer of the document.
Okay. So you said it was presented to you. Other than testifying here today in court, had you read through this document?
Through the entire document, no.
Okay. So your familiarity with this document, was it in preparation for this trial?
For the previous one and this one.
Okay. And would you agree that the policies and procedures in this document apply to everyone that is a employee of a particular school?
Yes.
Okay, so this document would also apply to the teachers in the classroom, is that correct?
Correct.
It would have applied to Ms. Kopak as a reading specialist, is that correct?
Correct.
Mr. Rawls in his position, is that correct?
Yes.
All right. And so based on these 2 documents, was there anything in these 2 documents that prevented Ms. Zwerner, Ms. Kovac, Ms. West, or Mr. Rawls from removing JT from the classroom?
No.
Okay. Is there anything in these 2 documents that prevented any of those 4 individuals, Zwerner, Kovac, West, or Rawls, from removing his classmates, JT's classmates, from his presence?
No.
Okay. So I'm going to actually go to the page 60 in the multi-hazard crisis emergency management plan, which the Commonwealth directed you to. Okay. Did you hear what I said so far?
I heard you say you were going to go to page 60.
That's correct. Okay. And even when he directed you specifically to a weapons threat. It says if a student or other person makes a threat with or about a weapon, it has bullet points. Are you testifying that each one of these things should occur?
Say that last part again, I'm sorry.
Are you testifying that each one of these things under this weapons threat should occur?
Objection, Judge calls for an opinion.
Your Honor, this is the policies and procedures of the school. She's here as an agent of Newport News Public Schools. She can tell us whether or not it's the responsibility of Newport News Public Schools employees.
That wasn't your question. She can ask you what does the manual say, but your question was whether or not it was following the circumstance. So I'm going to sustain the objection.
Okay, so I'm going to ask it in a different way, if I may. Ms. Zwerner, Ms. Kovac, Ms. West, and Mr. Rawls, were they was it their responsibility to follow these procedures?
Objection, same objection. He's asking for an opinion of whether they should have followed certain procedures,
All right,
all
well-
of them or few of them.
Response.
I can rephrase it to make it more clear, I guess. Are they obligated to follow these procedures? And I let him say this objection.
Okay, you object to that, phrasing.
It's been asked and answered, but I don't object.
Oh, you proceed with that specific phrasing.
Okay, thank you. So you would agree that if they thought that there was a weapon, that each of those individuals should have evacuated the area. Is that correct?
Correct.
For each of those 4 individuals, if they believe that there was a weapon, they should have.
Objection, Judge, this isn't the question that the court, he proposed to ask her, are they required to follow these policies? That was the question he proposed. That's the non-objectionable question. But he's going down into each of these policies and asking her whether specific people should have followed them at a specific incident or time. And that is an opinion. She has not been qualified as an expert in school security or any such thing. And she should not be offering an opinion about that.
It's not an opinion. She's testifying as to their rights and their responsibilities, Your Honor. So I believe she can testify to that.
State your question.
Was it their responsibilities when presented with
Whose responsibility?
Ms. Zwerner?
That's the same question, yes, that I sustained objection to. The next question.
Okay.
Did you hear him? Comedy in the chaos. Comedy in the chaos. Oh, did y'all hear that? He went, Okay, I'm going to rewind it just because we're going to hear that one more time.
Okay.
Same question, yes, that I sustained objection to. The next question.
Okay. Can I have a moment, Your Honor?
Yes, sir.
He needs a moment now. He's swirled now. He don't know what to do. He says, "Oh shit! Oh my beer! I need to go find something else. I don't know what to do." Oh, he need to go. Mr. Clean need to go talk to Afro Man for a little bit and say, "Hold up, now what do we do?" I'm sorry, y'all. Oh goodness. He did. He looked so like.
Ms. Ferris, Dr. Ferris, are you familiar with the training that Dr. Parker or anyone else may have had regarding the rights and responsibilities that are contained in this handbook?
No, I am not.
Okay. And would your response be the same to this document? Are you aware of any training that Dr. Parker or any of the staff members may have received regarding?
No, I am not.
I'm going to relinquish this witness to my colleague.
Your colleague, Mr. T? Okay, Mr. T.
He says it's lunchtime.
I'm going to object to bouncing back and forth between attorneys for a single witness and
It's not ideal, but I don't have the authority to say.
See, that's I was just fixing to ask that question. So they're passing it off to a different attorney. That's not very common. Where they let 2 attorneys go at the same witness. So, and judge says, "No, go ahead." So, all right. Yeah, we had a Lola visit. She was getting her butt scratched. She's got allergies and she's got a few little bumps and she needs her butt scratched. So,
This witness to my colleague.
Your colleague, Mr. T?
Mr. T.
Okay, Mr. T.
Thank you.
Your Honor, for the record, I'm going to object to bouncing back and forth between attorneys for a single witness and
It's not ideal, but I don't have the authority that says they cannot. Understood. And I think you got something, Mr. T.
Oh, thank you.
You dropped something, Mr. T.
Good morning again, Ms. Ferris. Are you Dr. or Ms. Ferris?
Doctor.
Dr. Ferris. You were shown a video of about 16 minutes earlier during your testimony, correct?
Yes.
Okay. At certain points of the video skips forward, correct?
The entire video, I didn't see a skip, but I saw a muting at certain sections.
Okay. So are you aware that the video was the entire?
No, no, not that Mr. T. Not that Mr. T. Okay, we'll stick with Afro Man.
The video is 28 minutes or 28 or 29 minutes.
Based upon the timeline I saw.
Okay. And you were shown about 16 or 17 minutes, correct?
Yes, as I recall.
And is it your understanding that the video clip that you were shown contains 3 different clips joined together?
The video that we saw here
Yes.
was the whole video except the end. It stopped before the very end. So I'm not aware that it's in snippets. It's the whole video.
Okay. So I'm going to pull up the video, the actual video, the whole video.
Okay.
Judge, I'm going to object to this. I don't know what the relevance of this is.
Okay.
So we switched lawyers.
To respond
We
to relevance.
we switched lawyers, and now this lawyer's bringing up the of it.
I'm going to ask the council not to put that up on the screen until we've addressed
That's fine.
Okay, he's objecting to relevance. What is the defense response?
It's relevant. The witness has testified that she does not believe that the video has been cut up and, certain parts edited out.
Say that, or did she say she wasn't able to see that?
She says that she believes that the entire video was shown except the end. That's what she just testified to.
Yeah, it's almost it's almost as good as the Afro Man trial. I'm telling y'all, Afro Man trial was off the rails. Okay, so if y'all ever need a good rewatch, Afro Man trial, we rock that shit. But this is like, I don't know what I'm doing here, and I just got the weirdest text, y'all. Okay, I have like 2 friends that I still speak to from childhood, like childhood, and I heard my phone go off, and I picked it up, and it's just a purple heart from my best friend from junior high school. She knows who she is, whether she's watching or not. But I haven't talked to her since February, so.
According to introduce and under what legal admissibility rule?
So best evidence rule, the Commonwealth has spliced the video, and he's cut out and skipped ahead in the video.
Which we acknowledge.
We acknowledge. So I would like to play more of the video that gives fuller context to the testimony that Dr. Parker was giving in the video.
Okay, and then we agree that the jury will get the whole video for deliberations. So your objection, and what you're gonna play is a part of this whole video?
Yes.
Okay, and so what's the objection?
Well, Judge, it is going to be in evidence. I've already fully stipulated that the version we showed is an edited version and that the full video goes into evidence. Now he's wishing to introduce evidence. We don't have that video, the full video in. So the defense is about to introduce evidence that he has, which they certainly introduce evidence in their case, but this is still the Commonwealth's case.
So the legal principle here, when we start with my ruling, I'm going to allow it and over the Commonwealth's objection. The basic thing is the whole video is going back there to the jury room for deliberation, and it's offered by the Commonwealth. The opposing side gets the right to cross-examine that, and to have it go back there with the ability to cross-examine is not a legally sustainable principle, does not apply to case law. So he gets the opportunity to cross-examine on anything that's going back there in the jury room. So that's the court's basis. You may proceed, Mr. T.
Thank you, Your Honor. And Dr.
Judge, I'm sorry, I just want to advise that the full video many times contains the name of JT.
Understood.
Okay, the whole name, not initials.
Correct. The
Okay,
whole
but
name.
how are we dealing with that, Mr. T?
Your Honor, I don't intend to play any portion that gives the name. I can ask some additional questions if we can. I can try to avoid
We're
it.
talking about, again, audio and press coverage to the world.
I understand.
So you're able to not to play portions that do not state and the names of any minors.
Yes.
Okay.
We've
But just to be safe, I'll just try to listen to testimony from her directly.
And how many times I think I've heard 3 times already. They say the child's name. I'm not going to say it, but they've already said it 3 times. And hi, Shauna. Sorry, I didn't pause. I try not to pause so much when they're right in the middle of talking, but we needed a break there. I am going to go refill my coffee. I can still hear y'all because, we did the earbud things today. So, I can hear y'all. Oh, I can't hear y'all. I can hear the court. Y'all see, it's another squirrel moment. I'm going to go refill my coffee, but I'm listening.
Then if I need to, I'll play the portions that I need to.
Playing video or not?
It would just depend on her answers.
Okay, you might. Okay. But understand we have that cautionary instruction. We are not releasing names of any minors. Okay, you may proceed.
Thank you, Honor. Dr. Farish, during the narrative that Dr. Parker was giving you in the video of what occurred that day, her actions, did she also mention that in the midst of all of this, she was also attending to 2 other students that were acting out?
Yes.
Okay. And that was not played in that video that you heard earlier, was it?
I'll just refer back to my notes.
Dr. Parker was not just in her office ignoring the rest of the school during the testing, correct?
Objection. It's an opinion about something that she did not observe.
I'll rephrase the question, Your Honor. From Dr. Parker's testimony to you regarding the events of the day, she mentioned that there were 2 other student issues that she dealt with in the school, correct?
Objection. That was the most recent question. It's been asked and answered.
I want to narrow down and go down the path of asking about these 2 other.
Okay, repeat your question again.
During the day, during the narrative that Dr. Parker gave you, Dr. Farish, of what was going on regarding her conversations with Mr. Kovac and Ms. Zwerner, she also mentioned that there were 2 other student issues that she dealt with regarding misbehavior, correct?
Okay, Roland, that's the question. What's the objection, Mr. Jenkins?
This is the second time he's asked that question. Her answer is yes.
Also, just ask and answer.
Yes.
Okay, you can ask it one more time. You can ask it. Go ahead. So overrule.
Okay. Do you need me to repeat the question, Dr. Farish?
Yes, she responded to other issues.
Okay.
Students' issues.
Okay. And one of them being a student was trying to elope from the school, correct?
Correct.
Okay.
Or a student who was an eloper.
An eloper.
Something that happened.
Right. And that was prior to the shooting, according to your interview of Dr. Parker, correct?
Correct.
Okay. Dr. Farish, you are an agent of the Newport News Public Schools, correct?
Yes.
All right. And you are aware that the Newport News Public School System is named in civil lawsuits stemming from this event, correct?
Correct.
Okay. And so your employer has a direct financial interest in these proceedings, correct?
Explain that a little more to me.
Would you, as far as you understand, would your employer benefit financially from having Dr. Parker be the one to blame for the shooting?
Objection, Judge. Hold on, objection. That calls for a legal conclusion. She's not an expert in litigation or how that works. And the question assumes facts that are not in evidence regarding another matter entirely.
And the foundation for having that not true information. So sustain.
Okay.
Nope.
You interviewed Dr. Parker within 2 or 3 days of the shooting, correct?
Correct.
3 days.
And she gave you permission to interview her and be recorded, correct?
Correct.
Okay. And she cooperated fully with you, correct? You also told her to keep the conversation confidential, correct?
Correct.
Is that here we go around the mulberry bush, or is that Here we go round and round. The only song I can think of is right round, baby, right round. And that's not even the right word. So see, don't get me to singing. Y'all, let's leave that to Afro Man, okay? Okay. And we will have lemon pound cake before we leave.
Did you ever tell her that she had the right to have an attorney present before speaking to you?
No.
Okay. Did you ever tell her that anything she said could be used against her in a criminal proceeding?
Objection, Your Honor.
A basis for your objection?
Judge, we're going to need to address this at sidebar.
Did you see, y'all? Did you see the way he snapped his head and looked at the prosecutor? Whoo! Okay, here we go. I hit play again.
Okay. Did you ever tell her that anything she said could be used against her in a criminal proceeding?
Objection, Your Honor.
A basis for your objection?
Judge, we're going to need to address this at sidebar.
I'm asking her what she advised Dr. Parker during this interview.
I'm not sustaining the objection. Next question.
Okay.
Whoop! Sustain. Next question. It's getting hot in here. So take off all your clothes. Oh, no stripping
According
in my
to your
room.
interview with Dr. Parker directed Ms. Kovac to search JP's backpack, correct?
Correct.
Okay. And as far as what Dr. Parker told you, Ms. Kovac did check the backpack and found nothing, correct?
Correct.
Okay. Ms. Kovac also told Dr. Parker that they watched him closely, correct?
If I remember the phrasing is that they were watching him.
Watching him closely.
Correct.
Okay.
You know, Cindy, coming from somebody who has, I feel like you're very knowledgeable in this area. You know, you here, I'll put me up here, so I actually feel like I'm talking to you. You know, you seem pretty knowledgeable in this area, so I'm always appreciating your comments and everything. I really do. I appreciate your knowledge in it because I know you've done some work in the social field. So I appreciate all your little input that you give. So I just wanted to tell you that. I don't know. I'm feeling. I don't know. Just shut up, Sheila. Okay, I'm gonna rewind this, man. Just a second.
Correct.
Okay.
Oh, you did? See, I knew
Ms.
there was
Kovac also
something.
told Dr. Parker that they watched him closely, correct?
If I remember the phrasing is that they were watching him.
Watching him closely.
Correct.
Okay. So is it your understanding that Dr. Parker had been told that there was no gun in the backpack and also that he had been closely watched during recess?
Objection. Can we clarify that what we're asking her is about the statement, not about the facts of what happened, but about the statement of Dr. Parker?
It's the same. I should be rephrased to clarify what you're referring to.
Okay. Well, I've already asked the questions. I'll move on. Dr. Parker also stated that JT's mother would be coming to the school to get him shortly, correct?
Correct.
Okay.
Yes.
There's something in background noise. I'm not sure where it's coming from. Somebody's cell phone or, but if we could try to take care of that first.
Yes, I keep hearing it and it's distracting.
Okay, well, Sheriff will be on top of that. And I'm hearing it too, yeah, we'll work on it. All right, thank you. And again, it's 12:23, we're gonna keep on again, we'll try to go to 1 for lunch, but do any of the jurors get a break? Okay, they're good, okay, proceed with your cross.
Thank you.
I don't have my squirrels, but you know what we do have? We have some dancing ducks. Let's do it.
Dr. Parker also.
Fucking mic's muted. They don't need a break. They don't need a lunch. Keep going. They're like, keep this crazy circus going, y'all. This is nuts.
Testified or said to you during the investigation that Ms. Zwerner never stated that the student had a weapon, right? Can I ask what you're reading?
It's a transcript of the video.
Okay. Do you have any independent recollection of?
I don't remember her saying Zwerner said.
I knew what you meant. He heard Hector's TV from Monday. That's what he was hearing in the background. And it's me hollering, turn it down. I'm gonna have to clip that and put it out on my own thing as a short, just so everybody knows. You know, I'm really crazy, guys. I enjoy ducking hell. Them are dancing ducks. Damn it. Ducking hell. You know, we have fun here. It's true crime. But like I always say, comedy in the chaos. Let's roll.
Didn't have a weapon. I asked her, did Ms. Zwerner ever say she had concerns about the student and the student being a threat to her or her feeling unsafe?
Okay. Do you recall when the video was played here in the courtroom?
That's what I was trying to remember if Ms. Zwerner said that. I remember Ms. Kovac saying she did not see anything in the backpack.
Do you recall the video today where Dr. Parker was speaking to you in an interview and she stated that Ms. Zwerner never came to her and said that the student had a weapon?
Yes.
Okay. And everything that Ms. Zwerner related to Dr. Parker was about behavior of the student, correct?
Correct.
Okay. She also mentioned that they had, prior to this incident, that they had two incidents at the school where there was a potential weapon possessed by a student, correct?
You're referring to two other times?
Prior to January 6, 2023.
Correct.
Okay. And she also mentioned to you that they've never searched the student without the parents' consent, right?
That they've never searched students.
Okay. And she was also managing state testing that day.
Correct.
Okay. Based on your investigation, did you conclude that this was foreseeable? The shooting specifically was foreseeable?
No.
Right. In fact, you came to the opposite conclusion, correct?
That is true.
In fact, you said that this is something that none of you could have ever imagined, correct?
I'm going to refer to my summary.
At any point, did you say something to the okay.
I just asked for a moment to refer to her notes.
Okay.
I do not recall making that specific statement.
Mm-hmm. Okay. But you do agree that this, based on your investigation, that this is not something that was foreseeable?
Correct.
Okay. Did you ever make the comment in the civil trial of this matter that this was something that you could never have imagined?
Objection, hearsay.
It's her own statement.
Correct. It's her own out-of-court statement being offered here for the truth of the matter. You can ask her what she believes today, now, but not what she said out of court.
I thought you said from the civil trial. Does that make it in court, or am I missing something here?
It's out of court because it's not within this proceeding. Yeah.
She says that she cannot recall, she could not at that time recall making a statement, and I believe I was asking her about the actual report itself that she created.
Okay, well then rephrase, because that's not the question as I understood it.
Okay. Did you ever make a statement during the civil trial that this was not a foreseeable incident?
Okay, hold on for your answer. So, assuming she said yes, which I don't know what her answer is going to be, are you going to ask her to give that statement?
I'm just want to know whether she made the statement.
So you just want an affirmative or a negative response?
Yes.
And your position is changed?
He's feeding her the statement and just asking her to say, didn't you say at the civil trial? He's going to give her the statement and he expects her to say, yes, I did say that at the civil trial.
I just asked another question. I said, did you ever make a statement to the effect that it was not foreseeable? That was my last question.
Exactly, to the effect that it was not foreseeable. At the civil trial, that is hearsay.
Okay, yeah, understood. And your response to that, Mr. T,
Your Honor,
how is admissible? What exception applies?
I can ask her about her statement. This goes to the foreseeable. You know what? I will try to question Your Honor. She's already answered that she has determined that it was not foreseeable. So I'll withdraw the question. Okay. No further questions.
Any redirect?
Yes, sir.
Dr. Farish, much has been made about your investigation. Do you have, as part of your investigation, did you complete a Rich Neck investigation report?
Yes,
And do you have that report with you right now?
yes.
May I approach, Your Honor?
You may.
Yes, Doctor.
Sure. I believe you have a copy.
Ooh, that was snark. That was snark. Did y'all hear that? I believe you have a copy. Ooh, doggies, that was some snark. Right? We don't have them here. We have to wait. We're gonna have voodoo doll. Hio, if you're listening, Hio, voodoo doll ducks, voodoo dolls. That in when we get to emojis, duck voodoo doll.
Judge, I've provided to the defense counsel a copy of the plan. Do I need to wait?
Review what you're presenting to the witness.
Of course.
To make sure that it is presented. Okay.
Is it?
Okay, you may approach.
Thank you.
Could you just take a moment to just look at each page of that, compare it with the one you brought with you, and let us know if it's an identical copy?
Yes.
All right, Judge, I move to admit that as
identical.
Commonwealth's 3, I think.
Your Honor, I'm going to check. This is an investigation, confidential Rich Neck investigation report that contains hearsay from other parties. It is not.
Response.
The court's ruled otherwise already. Counsel has been allowed to elicit her opinion, the results of her investigation. Counsel has cross-examined her about the conclusions that are in that document. We have had a full interrogation about the facts found by her investigation and her conclusions. To not give the jury that document now is misleading. And so for the rule of completeness, the defense has been allowed to go in and talk about, cherry pick little pieces that they want to talk about. And I'm seeking to admit the whole document so the jury can see it for themselves.
Ms. T?
Your Honor, we are on cross-examination about to ask about anything you want to ask about. It's marked in silver, the direct examination. This is a report that contains hearsay statements from other parties, just as the court has ruled that the jury cannot consider the statements of other people that were mentioned in the video, giving them a full report.
It's not just you, Cindy.
It's beyond the veil. It's not useful.
Let me see the document.
Of course, may I approach the deputy has it. Yes, of course.
Thank you. Appreciate you all.
Oh, now the judge is going to review it. Okay.
As to some of this. The court will allow a redacted version in, so I will sustain the defense objections as to some of this are not permissible based on the rule of evidence. The court's position is that page 1 and page 8 come in. So the cover sheet and the last page come in, the middle does not. I will remove this stick from myself. And does the Commonwealth want the portion removed to be marked Commonwealth rejected?
Yes, please, Judge. Thank you.
Okay. Thank you. We're not recommended. Commonwealth District 3, Commonwealth 3. Rejected 1. Rejected Commonwealth 1. Okay, you may proceed with your redirect.
Judge, may I retrieve Commonwealth 3 from the court to bring to the witness?
Yes, and I'm going to ask. I'll say, well, yeah, I do.
All right, Mastiff, thank you.
Your safe was work just as good as my safe was. Oh, yes, sir.
Dr. Parrish, for the purposes of these questions, I'll just ask you to refer to Commonwealth 3, which I have just handed you after it's been marked and entered by the court. There is a section on the second page of the two that were marked called Summary and Conclusion. Do you see that section?
Yes.
Could you please read it?
Yes. An investigation was conducted to review internal processes and establish if there were any deficiencies. From interviews, several employees were told that the student had a weapon. All instances were reported to Dr. Parker, assistant principal. An inquiry was made to Dr. Parker if the student could be searched.
Again, I'm going to object to hearsay. These those statements come from other people.
You asked the finding to be in evidence, findings in evidence.
Hot damn.
Please continue.
The book bag was searched independently by Ms. Kovac. Permission was never given to search the student. At no time was the principal, Ms. Foster, notified of any communications about the student and the alleged weapon. Dr. Parker never left her office to investigate the situation with the student. Dr. Parker never spoke to Mrs. Foster, although they communicated about other school business prior to the incident. Dr. Parker admitted to handling a prior search situation with another student earlier in the school year, where she brought the student into her office to conduct a search. Although she says previous students' persons was not searched, she admitted that these students were pulled into her office to search their belongings at a minimum. This process was completed with the police or another adult present. Dr. Parker never left her office on the 6th to pull JT into her office. Dr. Parker responded that she could not leave her office due to testing as the reason for responding personally to the report of the student possibly having a weapon. Mr. Werner, Ms. Kovac, Mr. Rawls, Ms. West, Mr. Sims, and Dr. Parker all had knowledge that the student was in possession of a possible weapon before 2 p.m. Root cause, failure to follow a process and to appropriately detain a student and conduct a proper search once first notified that a student has a possible weapon. Lack of urgency and attention to multiple notifications. Lack of training and knowledge of the staff on how to handle this type of threat.
Thank you. May I approach the witness, Judge?
You may.
I'll retrieve Commonwealth 3 after that and return it to the court.
Thank you.
Now, Dr. Parrish, previously when I was questioning you and then again with defense counsel, you were asked to read various sections of the Rights and Responsibilities Handbook, including that section on page 28 about principals and security officers under the direction of a school administrator may search students. Do you recall that document?
Yes.
All right, and that document is an authentic manual that provides all the policies that were in place at Rich Neck in the 2022-2023 school year?
The Rights and Responsibilities Handbook for the district for 22-23.
Yes, that's an official document of the district?
Yes.
Judge, I move to admit that document in whole into evidence as Commonwealth 4.
Okay. So out of what she just read, the main thing that I gathered is Ms. Parker has taken other children in her office and searched them with another person present, right? And that's what I gathered out of that. And that she did not do it with this situation because there was testing going on and she had to stay in the office. Is what that's what I gathered out of that. So if y'all gathered anything, type it in the chat. I'm gonna hit play. This has so many twists and turns. Okay, Cindy? Yeah, okay, all right. So long as I need to make sure I'm not losing my mind. I mean, this has had so many twists and turns, and I feel like the circus is all over the place with these changing lawyers in the middle of one client, one person on the stand. I'm just whoa.
I'll have to retrieve it from the witness.
Okay, you may approach.
Before that's anybody close to have a moment, please?
Yes, sir. You can still retrieve it, Mr. Jenkins, and you can pass it to Madam Clerk. I won't receive it until I get in the defense counsel.
The court order will come in, so.
Oh, all right, so this is Mark Commonwealth 4.
May I approach the witness, Judge?
You may.
Right, Cindy?
Dr. Parrish, could you take a look at what I just handed you and identify it?
Yes, this is the Newport News Public Schools Ridgeland Elementary 2022-2023 Multi-Hazard Crisis and Emergency Management Plan.
And is that a copy of the same document that you have that is the emergency management plan that I have asked you about and defense counsel has asked you about?
Yes.
Judge, I move to admit this in whole, unredacted as Commonwealth's 5.
In whole, unredacted.
You may.
Look, he says, look. Okay, here, I'm gonna get ugly. He's like, look, damn it. We're doing this whole thing. It's coming in unredacted. They're gonna see it all. I ain't playing no more. Look, and he's getting a little spunky, spicy. Whoo. I do have it sped up, but it's on 1.2. It's not like 1.5 or 2. It's 1.2. So that's not reflection of voice.
Objection, which was previously ruled on for the record was made.
And I have no further questions for the witness, Your Honor.
Thank you. May we recross?
Yes, Your Honor.
Okay,
right. Now, Parker was in the wrong test. Parker got tested. Not to be rude, but Parker got tested.
Dr. Parrish. Again, the portion of the report that was just entered into evidence, your investigative findings. You were conducting that investigation on behalf of Newport News Public Schools, correct?
Correct.
Okay. As far as your findings, you were not assessing or giving up any opinion on whether Dr. Parker's or anybody or any other employee's conduct was criminal in nature, correct?
Correct.
You also mentioned in your root cause section of your report a lack of training and knowledge of the staff on how to handle this type of threat, correct?
Correct.
And you're referring to the staff as a whole, correct?
Correct.
And according to your report, all of the, I'll just name them specifically, Ms. Zwerner, Ms. Kovac, Mr. Rawls, Ms. West, Mr. Sims, and you say Dr. Parker.
Got me. Wrong pipe.
Your finding is that none of them responded adequately, correct?
Objection, Judge. I think that misstates the evidence.
To respond adequately, I do think it's
misstates those, Cindy.
Okay. All right. In your root cause section, you write failure to follow a process and to appropriately detain a student and conduct a proper search once first notified that a student has a possible weapon. Does that apply to all of the people I just named? Ms. Zwerner, Ms. Kovac, Mr. Rawls, Ms. West, and Mr. Sims, and Dr. Parker?
Yes.
Okay.
Uh-oh. He got lucky, Southern.
I have a follow-up, Judge.
Yes, sir.
I'm trying not to eat on screen. That's why I keep turning my camera off so I'm not eating my cheese balls in front of y'all.
In the root cause analysis section, is there a phrase that cites the failure to search?
Yes.
And according to the Rights and Responsibilities Handbook, what does it say about who may conduct a search specifically?
That was the word.
We took it away from you. Can
That's okay.
I please retrieve Commonwealth's form?
4.
5, the Rights and Responsibilities Handbook. And I can give you a page site. I'll direct your attention in Commonwealth 5 to page 28, the paragraph that begins principals and school security officers.
Principals and school security officers under the direction of the school administrator may search students and student property.
All right. So given the root cause analysis that involves the failure to search, who was authorized by the district's rights and responsibilities to search?
Well,
The school under the direction of the school administrator.
Okay. And are teachers that work in a school considered school administrators?
No.
Are reading specialists that work at a school considered school administrators?
No.
All right. Thank you. I don't have any further questions, please.
well, kapow on that one. Okay. Oh, shit. Here we go.
Okay, so this, so that paragraph, it starts out principals and school officers, and then it, comma, under the direction of a school administrator.
Objection. I object to counsel reading whatever he's reading from. The witness should be the one reading from the exhibit that the witness has.
Wah, wah.
Are you reading the same thing the witness has?
Yes, ma'am.
I need to get some sounds for my soundboard thing.
All right, so I'll read it again. Principals and school security officers, comma, under the direction of a school administrator. So would you agree that when it says under the direction of a school administrator, it's referring to somebody other than a principal or security officer?
The verbiage we use at the school district for administrator includes a principal and assistant principals. They are administrators.
Okay, but as this is read, it seems to indicate that they need to have the direction of somebody above them. Do you not see that?
Under the direction of the school administrator.
Principals? Okay, so if I take out, it says principals, I can take out and school officers. So principals, comma, under the direction of a school administrator. So that
Dirty
seems to
cough.
indicate there needs to be some authority above the principal. Do you disagree with that?
Same, Mr. Jenkins, same. Next question.
That's all I have.
Okay, the status for this witness, is she get excused or does she need to remain sequestered?
I ask that she remain constructively sequestered, but of course able to.
Mr. Rogers?
Yes, sir.
Okay, all right, so Dr. Bailey, that means you are still a witness for purposes of this trial. You cannot discuss the case or discuss your testimony until you receive information that the trial is over. But you do not have to remain in the building or the witness room.
Okay, they went to lunch finally.
Next question, please.
But before we get to that, let's flash back because we can. Just because we all need that giggle. Okay, let's flash back. Let's go over here. We're gonna listen. We don't need no chat. We're just gonna listen.
Said to still wonder
What? Thank you, ma'am. Auto injury claim adjuster.
so disturbed that those who dared
What?
to
48. Thank you, sir. What? 63. Surgical technologist. Thank you, ma'am. 64. Designer and engineering department in Newport News Shipyard. Did I miss anyone?
Is there any ice? Oh, y'all just never know. My house is just, I'm surprised mom can say, I gave Mom a piece of lemon pound cake before I sat down, so.
On day 3, after the lunch recess. Anything to take up before we bring the jurors out?
Nothing from the Commonwealth?
All right, bring the jury.
Report to the court.
Calls Mark Garcia.
Mark Garcia. Come on, Mark. File in. Open them doors. Come on, Mark. Mark. Oh, hi.
Do you swear or affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth?
All right, Mark, take your seat.
Adjust the microphone, please answer questions the attorneys may have.
Good afternoon, sir. Would you please tell us your name?
Mark Anthony Garcia.
All right, sir. And I know that I mentioned this to you earlier, but just as a reminder, we're not saying the names of any children at all today. You're welcome to use initials or refer to them, like my son, for example, but no names.
My son. Okay. So one of his kids was involved. What did he say his name was? Mark what?
Want to, do you have a son?
Yes.
And what is his initials?
MJ.
Right.
Okay. Not
Did
his son.
MJ attend
MJ. Okay.
Rich Neck Elementary School?
Not JT.
Was MJ in attendance at Rich Neck on January 6, 2023?
Yes.
How old was he then?
7.
On January 6 of 2023, did you go to Rich Neck Elementary School? Well, first of all, let me ask you this question. Did you take MJ to school?
Yes.
So was that in your car? Did you personally drop him off?
Yes, I drop him off every day.
Okay. And on that day, did you go back to Rich Neck Elementary School sooner than you normally would?
Yes.
When you arrived there, I want you to describe what you saw occurring without telling me what anyone was saying.
Okay. Well, getting there was a task because once you get to Jefferson, going down Rich Neck, it was kind of like caught on off by the cops and a lot of people trying to go there. So we had to go to the adjacent road, which is Monroe. And we had to come down Monroe, and we got to Monroe, we had to stop because there's a lot of cars. So
Okay, I'm gonna spec this back down to 1.0 because this guy is a fast talker. Y'all hear him talk? Good Lord. Ooh. He talks like me. Give him a microphone and he can just
going down Rich Neck, it was kind of like caught on off by the cops and a lot of people trying to go there. So we had to go to the adjacent road, which is Monroe. And we had to come down Monroe, and we got to Monroe, we had to stop because there's a lot of cars. So I parked my car at somebody's house, and he said we could park there, and I got out my car. And, I parked my car, and I went down the road, and there's a church that's on the right-hand side, and that's where everything was caught on by the cops, and that's where all the confusion was going on because nobody knew what was going on.
So did you go to that church area where people were gathering?
We went in the middle of the street.
Okay. And did you immediately see MJ there?
No.
Okay. From the time you arrive, and I know I'm asking you to estimate, but can you give us an estimate? Are you able to give us an estimate of how long it was from the time you arrived at Rich Neck to the time you saw your son?
Response.
This is the connection, Judge, that we have been talking about in this case between the shooting and the ensuing trauma to the children. And that came from a delayed reunification. And that came from, as we will hear in a moment, that came from the continued chaos leading to these children in a panic and a state of trauma.
Your Honor, I'm going to continue to object. Even his response to this is a narrative testimony in front of the jury.
What's the nexus to why we're here? And I guess I'm missing that. If you can expand on that, if not, it's sustained.
The nexus for why we're here. Let me look at the statute and read from the statute. 18.2, 371.1. Any person responsible for the care of a child under 18 whose willful act or omission in that care was so gross, wanton, and culpable to show a reckless disregard for human life is guilty of a Class 6 felony. As to how
A delayed reunification.
the shooting, Judge, the shooting occurred, and everything that has happened to these children is a follow-on from the shooting that establishes it is gross, wanton, and culpable behavior of Dr. Parker. It was the willful omission that caused these children to be separated from their parents in a state of chaos.
I sustain the objection. Next question, please.
Mr. Garcia, after you were reunited with your son, describe his demeanor, how he looked to you.
Objection again to relevance, Your Honor.
He can describe that out loud. Overruled. You may answer the question, sir. You need him to repeat it?
Okay. My son looked confused. He was very scared and very shocked that all of this took place in his school, which he loved.
All right. And are there any ways that you've noticed as a parent that your son is different was different after the shooting versus before the shooting?
Yes.
Describe what you noticed.
Objection
And objection to relevance.
Okay, I didn't hear, okay, leading and relevance. He can describe what he observed when he sees his son. Go ahead, overruled.
So my son, he's in therapy. He has to go to therapy now. He's still scared of the dark areas in which they have to be pushed into their safe room. He's not comfortable in certain situations like he used to be, like being talkative and things of that nature.
Objection, Your Honor. If I can just sort of flesh this out a little bit.
Yes, sir.
Even regarding the statute, the things the Commonwealth has to prove, this is, the things that he's testifying to is not a material fact that has to be proven or established to prove that Dr. Parker is guilty of this crime. He's testifying as to things that occurred afterwards, but nothing regarding Dr. Parker's conduct or lack of conduct. So it's not relevant.
Response?
I'm going to tell y'all why I'm having a little bit of a problem here. I'm having a little bit of a problem because they're traumatizing this father again. And that's fucked up. I'm very bothered by this right now. This that I'm watching, it's very, I mean,
It's not relevant.
Response?
Child abuse and neglect requires a showing that the abuse is so gross, wanton, and culpable that it showed a disregard for human life. The effects of the abuse are what he is testifying to. That is what is gross, wanton, and culpable. And we're there. This is as far as I'm going with this. But the fact that the child is different after than before is relevant to whether the choices Dr. Parker made were gross, or the omissions were gross, wanton, and culpable, because this is the after effect to the children.
You're right, Cindy.
It can end here, but again, I'll let you finish, Mr. Rogers. But as to where we are now, I'm going to overrule defense objection. You can ask that one question. The gentleman may answer that question, but then we're going to stop. Yes, Mr. Rogers.
Just for the record. Your Honor, I might agree with Mr. Jenkins if the Commonwealth had to prove some type of serious injury, but that's not what it's charged. It's felony abuse and neglect, but it's not based on any injury. It's based on my conduct and not any impact on these children.
Anything additional?
Not from me, Judge.
Okay, do you need the attorney to repeat his question?
Yes, please.
Okay. How was your child different after the shooting versus before?
Yes.
Describe how he was different after.
Would you like me to describe before?
If
You
you,
have to answer the question
Yeah.
that he asked.
Okay.
Yeah.
So after, again, my son, he doesn't like sleeping in the dark because of being in that safe room for however long they were in that safe room. Being confined
No way,
to an area,
Cindy.
I don't know how much light it was, but he's scared of the dark. Having added more light and going to therapy.
okay. And were any of those things present prior to the shooting?
No.
All right, thank you. I don't have any further questions for you.
Good afternoon, Mr. Garcia. I just have a few questions. Are you familiar with any relationship that your son had with Dr. Parker?
No.
Okay. Your son was a second grade student at Rich Neck, correct?
Correct.
So he was not in Ms. Zwerner's classroom, correct?
No.
Okay. You mentioned something about a safe room. Isn't it true that your son was in the gym?
No.
Your son was not in the gym when you picked him up?
No.
Okay. Where was he?
I don't know.
Oh, you don't know?
No, we were told by the police.
Oh, well, I'm not asking you to tell me what somebody told you.
Okay.
So you don't know?
No.
Okay. You filed a civil lawsuit arising from the events on January 6, 2020.
Oh my God. I had a feeling this was coming. Anybody else see this coming? Anybody? When I knew he was a parent, once I knew he was a parent of a student, I thought, oh shit, here we go with the lawsuit thing. Who cares? That has nothing, that's irrelevant at this point. Right, Cindy. And
Three, correct?
Correct.
Okay. And it's filed here in this courthouse, correct?
Not sure.
You're not sure?
No, I did. You have to talk to my attorney on that.
I'm sorry?
You have to talk to my attorney on that.
Okay. You have named Dr. Parker as a defendant in your case, your civil case, correct?
Correct.
And you're seeking money damages from Dr. Parker, correct?
I'm not going to talk about that on camera because it's streaming.
Judge, I am going to make a little.
did y'all heard what he said? I'm not going to talk about that on camera. Cut the stream. Get the fuck out of here. Y'all, oh my God. I'm oh, my little heart.
You have named Dr. Parker as a defendant in your case, your civil case, correct?
Correct.
And you're seeking money damages from Dr. Parker, correct?
I'm not going to talk about that on camera because it's streaming.
Judge, I am going to.
Oh, because you're streaming it. It didn't say cut the stream. He said because you're streaming it.
Any civil suits relate to the children, and I think what he's requesting is that we not be on the air for this discussion and the cameras not continue recording while he discusses his child. And I support that request and ask the court to do that.
Wait. Squirrel my brain. They just said to cut. Wait.
Children, and I think what he's requesting is that we not be on the air for this discussion and the cameras not continue recording while he discusses his child. And I support that request and ask the court to do that.
Response.
Well, Your Honor, he just asked a series of questions about the child on camera. I'm asking about a civil case, asking him whether he filed a civil case. Has nothing to do with the child himself.
So the objection is overruled. Cross-examination, the questioner is allowed to examine the witness's interest in a case. And for the witness, we are not using names, we are using initials as we previously did. So that is the protection to minors in this case. All right, you may proceed, Mr. T.
Mr. Garcia, you are seeking money damages from Dr. Ebony Parker in that civil case, correct?
Yes.
And a criminal conviction of Dr. Parker would assist in your civil case against her, wouldn't it?
I believe so.
Okay. So you have a financial interest in the outcome of this criminal trial?
Financial? What do you mean?
Well, you just stated that you believe that a criminal conviction of Dr. Parker would assist you in your civil case where you're suing for money, correct?
Yes.
Okay. So you would agree you have a financial interest in the outcome of the criminal trial, correct?
Possibly, yes.
Okay.
This just went so sideways.
When did the school first contact you about the shooting?
January 16th.
16th?
Yes.
Okay. So 10 days after the shooting occurred. Okay.
Wait,
and how did you get that notification?
I was called by the city, the Newport News Public Schools, I forgot the name of the downtown director of people, but I know her name is, but she called me at 6 o'clock on the 16th.
Okay.
Yeah. Right, Cindy?
And do you consider that failure to notify you for 10 days a failure?
Absolutely.
And do you believe that failure is on the part of Newport News Public Schools?
I believe it's on the part of the school system as well as Newport News Public Schools.
Thank you. No further questions.
Any redirect?
Yes, Your Honor. You've indicated on cross-examination that your son, NJ, was not in Ms. Zwerner's classroom. What was his homeroom?
His homeroom was Mrs. McAuliffin's class.
And did he have occasion to interact with other students from other classes?
They're in the same hallway.
Now, in the immediate aftermath of this, when you picked him up, did he tell you anything about
y'all, I'm with
contact
y'all.
he had had with another
I see what
student?
you're typing.
Objection, relevance, and hearsay.
Okay, and I was going to ask you, are you asking me to give the statement or just to?
I am going to attempt to establish possibly an excited utterance.
Okay, all right, so there's an objection.
Yes.
What's your response?
What is the legal basis for the objection? I missed it.
If you could repeat, Mr. T.
Relevance and hearsay.
Okay, so it would be hearsay unless the court finds that the excited utterance exception applies. I'll need to lay a foundation for that.
So if you could lay a foundation and to the witness, sir, when we ask you to pause, we can make sure that the evidence is appropriate under the rules of evidence. You may proceed.
In the immediate aftermath of the events, right when you see your son, does your son speak to you about the event?
Yes.
Does your son tell you about a child he interacted with that day?
Yes.
Okay. And do you know who, just a yes or no question, do you know who that child is?
No.
Okay. When your son is telling you this, can you describe for us, without saying what he said, can you describe his demeanor, how he appeared and how he was acting and how he sounded?
He was scared, shaky, and nervous.
Okay. Did he relate to you something that had just happened earlier that day?
Correct.
Judge, I think that is sufficient foundation for as to hearsay under the excited utterance.
Yes, sir. And on the defense.
Yes, Your Honor, he has, Mr. Cumberland has not established any foundation regarding excited utterances. We don't know how long before, and if we're talking about the shooting that had occurred at 2 p.m. and the father didn't pick up his child until sometime later in the afternoon, presumably hours later, then I don't see how it qualifies as an excited utterance.
May I respond to that, Judge?
Yes, sir.
The excited utterance exception is extended when the declarant is a child, because courts have recognized in Virginia the nature of being a child and brain development means that the heightened experience of an emergency extends quite some time. There are cases that I will have to look up if the court would like that involve many hours long when the child is young. The younger the child and the more traumatized they are acting, the longer the extension of the excited utterance is.
I am going to sustain the objection. The legal basis would be as such. Reading Rule 2:803, excited utterance. So an excited utterance is defined as a spontaneous or impulsive statement prompted by a startling event or condition and made by a declarant with firsthand knowledge at the time under circumstances negating deliberation. Again, my pauses are to show the pauses and breakups and how to decipher that. It has not been established that the declarant, which would be the witness's son, had firsthand knowledge at the time, as he was not in the affected classrooms, and there's been no evidence other than being a student at school since it happened, as to how he would have gained firsthand knowledge through an appropriate way. So I'm going to sustain the objection.
I'm going to request to voir dire the witness so that I can establish exactly that.
Okay, you're asking to do so out of the presence of the jury.
Yes, Your Honor.
All right. Ladies and gentlemen, if you kindly retire.
So I'm going to read y'all something that I screenshotted that is, I believe, somebody that is related, not personally, but to the story, and I'm not going to give the name, but they did make a comment in, I believe it was a court TV chat, that JT is in legal custody of his great-grandfather. He attends a new school and has no contact with his mom until he turns 18 by court order. So that was a very interesting little piece of knowledge that I screenshotted. I'm not going to give the name of who it was, but that was, I had been watching them through the chat as they were typing, and I felt confident that they obviously have a little bit of background and stuff that I'd seen. So anyway, so that I felt that was quite interesting to know. So
Next witness.
Commonwealth will call Susan White.
okay, so they took a short break.
Susan White.
Susan White.
Thank you.
Susan White. Yeah, really, Cindy. I agree. Teresa, what you do in the privacy of your own home is not our business. Okay. Okay. Yeah, and that was something else. They did say that was also put in that chat that I was reading through. So, yeah, he is receiving mental health support. So, yeah. And I
Raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth? I do. All right, you just have to give it.
right hand.
Your Honor, if I may.
Yes, sir.
I know the court has already ruled on Mrs. White's.
I mean, come on, hold on one second. Come on in the witness stand and watch your step. Yes, you can move the chair and microphone. Yes,
The court's already ruled on Mrs. White's ability to be able to testify today. I'm renewing my objection to any testimony she will give regarding how it's not relevant to what happened on January 6th regarding my client's conduct in the actual mission that occurred on that day. She can't testify to that because she didn't observe it. So I don't believe that she has anything of relevance to offer the fact finding here to decide if my client's conduct is appropriate on it.
So no, thank you. You may speak, Mr. Chairman.
It's a good question, Hannah.
Good afternoon. Tell us your name.
Susan White.
Ms. White, how are you employed?
Right now I'm retired.
And on January 6th of 2023, how are you employed?
I was retired by then too.
Okay. And were you at Rich Neck Elementary School?
Yes, I was.
Why?
I was there for 34 years.
Okay.
And my last year was the year before
Right.
that happened.
And so I want to take you back to the year before that, which was that your final year before retirement?
It was.
Okay.
No, I'm sorry. I don't believe her answer was responsive to the question. There may have been a misunderstanding as to what was asked. So it definitely wasn't.
Okay, you can clear that up on cross-examination. You may proceed, Mr. Jenkins.
So during the course of your last year of teaching at Rich Neck, did you know a student who we're referring to as JT?
Yes, I did.
Okay, and as a reminder, we're not speaking the names of any students at all, only using initials. Whose class was JT in?
My class.
And what grade was that?
Kindergarten.
Okay. During the course of your time with JT, was there ever a discipline incident that you did report directly to Dr. Parker?
Yes.
I want you to start at the beginning of that incident that you eventually reported. So what was going on that day that began that?
He had gone up. This was during post-COVID, so we had to be careful with distances and with masks. And he'd gone up to the front of another child's desk with his chair and put his face over about 3 inches from the other child's face. And so I had to think, what am I going to do about this? Because just telling him no, or you need to get back to your seat or whatever, those weren't working with him. So I slid the chair slowly so that if he wanted to get up, he could get up. And if he didn't want to, he could stay seated. I was going to bring it to his desk. But then he pulled the legs away and dropped them. And so I brought it up a little bit further just so I could be right in front of the class. And I sat there and I kept on teaching.
Okay.
I was still talking with the students.
Let me pause you for a moment so we can kind of, visualize this scene.
That was
So,
you do the hokey
when
pokey,
he is in the
and you
face
turn
of
your-
another student, how is he? Is he sitting, standing, or doing something else?
He's sitting, leaning in toward him, staring him in the eyes.
Okay. And you testified that you pulled him away. Could you describe how you did that?
I slid the chair from, I was holding the back of the chair and I slid it back. We had no carpets at that time because of COVID, so it was easy enough to do.
Yeah.
And so he hopped off and grabbed the front legs of the chair and pulled them forward. But I was able not to fall, but to still hold on. So I could get it a couple feet further and I just sat on it.
So when he pulled the legs, had he stood up out of the chair?
Yeah.
Okay.
Oh, yeah.
So what happens after that point?
I was sitting in the chair and I was talking to the class, and not about behavior, about the instruction we were doing. And he walked up behind me and put both of his arms in front of my throat and locked them together and pulled back and down hard. I couldn't breathe. And he didn't let up on it. The only way I got out of that situation was the assistant, the teacher's assistant that I shared with another teacher, happened to be in there at the time. She was in the back of the room. So she came up and pulled him off with me and took him out of the room. But until she pulled his arms off, I couldn't breathe.
What, if anything, happened with JT immediately after that? Does he remain in your room?
This is insane.
No, I wouldn't have had it. I would have left if he did. No, Mrs. Parker, my assistant, took him out of the room. But then, sometime later in the day, and it got very blurry after that for me, so I can't tell you how long. One of our counselors and our security officer came and brought him back to my room.
So when you say, hold on, when you say brought him back, do you mean JT?
Yes.
Okay. So when
They
you
each had him, I'm sorry.
when you see him come back to your room with the counselor and school security guard, what happens?
They each had him by one hand, and they were trying to get him to move into the room. And he was yelling, no, I don't want to go back in the classroom.
I need to know how big this kid is. I need to know how big this kid is. Is he like a 5'6" that weighs 120 pounds? What the fuck is happening? Look. I appreciate you, 80s. You're always so kind to come through here. Thanks for dipping your feet in the duck pond tonight. I really do appreciate you. Wow. Cindy, I'm look, geez, wow. Y'all are like me. I sunk down in my chair. I literally just I sunk down and I'm like, what in the ever loving hell is happening here? It's crazy. And you know what? If you haven't subbed up to 80s, Cindy, I don't know. You know what? I'll do it real quick. We're gonna squirrel for a minute and I'm gonna drop 80s link because if you haven't subbed up to him, he does music trivia. Let's see. Let me see if I can find him. Let's see. Click here. Go to channel. Here you go. I'm going to drop it in chat. He does gaming and he puts little posts up that are 80s music posts and I love them. I love looking at his little posts and trying to figure out the answers to some of his posts. So if you haven't subbed up, that might be somewhere you like to go just to kind of hang out and see what he's doing over there. What kind of questions he's asking if you're into those 80s music questions. Some of them are hard and I can't answer them, but they're there. So anyways, enjoy. Thank you 80s for stopping in here. You're always so kind. I go into his chat when he's gaming and I throw in ducks. Because he comes in here with his dirty feet, but he cleans them now. He knows to put them in the duck pond and get them all, but get them all clean before you walk through now. Appreciate you, sir. Anyways, so yeah, there you go. He gonna put ducks in here for me now. He got clean duck feet. Right. Cindy, there's so many questions. There's so many questions. And I really would like to know how big this kid is. Seriously. I mean, there's some big kids out there. I mean, my nephew, great nephew, I didn't get to see him for about 8 months. And he turned 5 during that time frame. And I didn't get to see him for his birthday and all that. But when I did get to see him, like I said, it'd been a little bit. And he grown so much. He grew like a weed at that age and gained weight and stuff. So that's what I'm like. I'm very curious as to how big this kid is. And ma'am, I'm sorry for that screen pause like that with your mouth wide open.
And when
In school.
I'm sorry.
When you see him come back to your room with the counselor and school security guard, what happens?
They each had him by one hand, and they were trying to get him to move into the room. And he was yelling, no, I don't want to go back in the classroom. And I looked at them, and I had his back to the doorway so I could talk to them without everyone in the classroom hearing. And I said, well, he's right. He does not belong back in the classroom. What he did was severe enough for me to contact the police and to press charges. And the security officer agreed with me.
Okay, so what happens with JT next?
Well, they told me they were bringing him back to me because no administrator was available to handle the situation.
Okay.
So I said that if he was going to stay in there, I was going to need to leave the room.
Did you in fact leave the room?
I did, but not because of that. I believe they took him back out again, but it's very fuzzy.
Okay.
What I know is by that point I was so shaky that Mrs. Carter, my assistant, said, go ahead and take a break. And I took my laptop and went to the lounge and got the incident referral form because I wasn't going to leave school without reporting that.
Okay, so hold on just a minute. You've mentioned an incident referral form. Can you just kind of explain to the jury what that is?
That's if you think that the discipline.
And that's exactly why he doesn't have charges against him for all this. What is even happening?
Reporting that.
Okay, so hold on just a minute. You've mentioned an incident referral form. Can you just kind of explain to the jury what that is?
That's if you think the discipline problem is dangerous enough or bad enough that you need to refer them officially, formally to the administrators.
And when you say the administrators, what titles do you mean?
Assistant principal and principal.
Okay. And who was the assistant principal at Rich Neck Elementary School at the time that this happened?
Dr. Parker.
And is Dr. Parker in the courtroom right now?
Yes.
Could you just point her out, please?
She's right there.
Okay. Will the record reflect that she's indicated dependent?
I was not, can you point her out again? I didn't see your name. Okay, so no.
Thank you, Jim. So you've told us that you got an incident referral form, okay? And what did you do with it?
I filled it out and I typed up a whole description of everything that had happened that day because I had had some positive moments with it earlier. So I wanted those included too. So typed up the day and then I attached it to the referral form as the attachment and the explanation of the behavior. And then I went to the office and I saw that Dr. Goodman, the principal at the time, and Dr. Parker, they were in her office at the time.
And did you go into the office?
I went into the office. I told them everything that had happened.
So let me ask you this question. Did you have the incident referral form with you?
I had it in my hand.
Do you know who you handed it to or what you did with it?
I handed it to Dr. Goodman after I explained everything on it to both of them.
I understand. So after you explained everything that was on it, if you remember, did Dr. Parker or Principal Goodman react to that in any way? And if so, how?
Dr. Goodman did, when I was talking about the fact that if an attack is occurring, it should never be that no administrator is available to help with it unless there's a worse attack going somewhere at the same time.
Okay. Did Dr. Parker say anything or
No,
have
she was making eye contact. She was looking at me. She didn't say anything.
Okay.
Dr. Goodman said, sort of under his breath, prioritized. And I thought, well, yeah, that's what I wanted him to get from that. And then he told me to go to the nurse and have my neck checked out afterwards.
Okay. That year, did JT ultimately return to your classroom or not?
He did.
Okay.
He returned the very next day.
Get the fuck
He
out.
walked in with his breakfast.
Okay.
And I immediately went to the teacher.
He came back the next day to her class. Cindy, my nephew's Baker, active for schools in first grade. Spazzing out, stabbing the principal. Oh my God. Good Lord. Yeah, they knew he was having problems. Yeah, this is crazy. This is crazy. Yeah, no wonder she retired.
Did.
Okay.
He returned the very next day. He walked in with his breakfast.
Okay.
And I immediately went to the teacher across from me and said, I need to go to the office so that she would watch both of the classes. And she saw who I had with me, and so she understood. And I just told him, he had his breakfast with him. I said, just bring it and come with me. And so we went to the office and I had him sit down in the waiting area for parents there. And I went into Dr. Parker's office. And I knew at that time that my assistant had to stay in the first grade class all day because the sub hadn't showed up. So I would not have another adult in the room. So what I told her is, I cannot be the only adult in the classroom if he's in that room. And so either he needs to be somewhere else or I'm gonna have to take a sick day and go home.
And was he relocated or what happened?
He must have been, because I went directly back to the classroom and continued teaching for the day. I didn't see him the rest of the day.
Okay. At some point later in the year, does he come back to your classroom?
No. Sorry, Cindy.
If there were, and if you remember, any other discipline incidents you saw yourself and you reported to Dr. Parker yourself, are there any such incidents?
With him?
With JT, that's right.
No, I don't believe so.
Thank you so much. I don't have any further questions for you. Please answer any questions of the principal.
Okay, but that one incident would have been enough for me. You know what I'm saying? That one, sorry, no.
I'm sorry.
Okay. Are you all right?
Yeah, I'm okay. I thought he was asking me.
I'm sorry. Take a moment to confirm.
Southern, I feel the same way. I mean, it has been one thing after another. Just
that you reported.
The school, the parents, the And now to know he was what with was it his great grandfather? Yeah, his great grandfather. So, I mean, this poor child, how did he get where he is now? Well, at that point, and why did he get there? Why did he have no? Sheila, be quiet. Sheila, be quiet.
It's like, you just testified that you reported JT's behavior or his presence in your classroom to Dr. Parker directly when he came back the next day, correct? Okay. And then when you told her that, after that, he never appeared in your classroom again, correct?
Right. And I heard.
No, you don't tell me what you heard.
Okay.
So when you told her that action was taken and justice was JT was removed from your classroom.
He went to another school.
Okay. All right. Regarding the incident referral that you mentioned, do you know whether Newport News Public Schools retained a copy of it?
I was told they didn't.
Okay. And did you have to then supply it to someone else, your own copy that you would maintain?
Yes.
No further questions.
And read the record.
Yes, Your Honor.
You are right with that, Teresa. They all have, almost every one of them, there is some type of history behind them, or they leave these manifesto of notes of things that were going on that were pretty obvious, but nobody paid attention to.
Ms. White, I want to just direct your attention to the incident referral form.
Things overlooked.
You've indicated there was a form. Was that the only piece of paper you submitted?
I submitted the referral form with the attached description of the day.
Okay.
So that I could get the full explanation of what happened, because this little place is not going to be enough.
Understood. And the a description of the day that you attached to the referral form, was it typewritten, handwritten, or something else?
Typewritten.
All right. If I showed it to you, would you recognize it?
Definitely.
May I approach the witness, Your Honor?
You may.
May I see the exhibit?
You may.
Sure.
That too, Southern. That too. I mean, I'm over here in my thoughts and my fifis of, you don't ever want to blame parents, but I look back at the fucked up shit I did and know why Muffins is screwed up the way she is. So, and it took me forever to get myself straight, which in turn took forever for her to get herself straight. It's kind of irrelevant. I'm not sure even why I said that. I guess just being a parent and thinking of taking care of your child. And I'm thinking, where was the parents? What was going on? What was the crisis, the thing, whatever going on that caused this child to be so different? Let's just say different. Yeah. And there was no effective intervention for him, whether they were offered or declined or not available, as adults failed him as child. The adults failed his child. See, I don't know.
May I first witness, Your Honor?
You may.
What is it that I paid you?
You handed me the detailed description that I attached to that incident referral form.
Okay, and is what you're looking at now a true and accurate copy of the incident report as you wrote it?
Yes.
Has anything been redacted from it?
Well, yeah, but I did that myself for some that I gave to other people.
What was redacted? Is it a category? I don't know, I sort of words. Is it names?
Names.
Hold on one second, ma'am. What? Yes, sir.
Before she even answers that, objection, that document is hearsay, it's an out of court statement, it's written, being offered for its truth of what happened on that day. She's testified as to what occurred. She's testified that she produces incident report, but as far as the contents of that incident report, I'm objecting to it as hearsay.
The objection is premature. I haven't offered it as evidence yet.
It was leakage, Hannah. Leakage.
Premature, not yet right. You may proceed.
The redactions that appear are the redactions that you did.
The names, yes. I don't know what I had at the top.
Okay. Are you sure that that is the incident referral that you submitted attached to the form?
It looks like it.
Okay, it either is or it isn't. Take your time to read it.
Yeah. I was gonna say I write a lot, but yeah.
So is it the incident referral?
Mm-hmm.
Is that yes?
Yes, it's the attachment that I attached to.
Thank you. Judge, I am moving that now into evidence as Commonwealth 6 as a past recollection recorded for one thing, and also as.
Okay, here. Comedy in the chaos. She's pale like me. Just saying.
As a prior consistent statement, because the defense was alleging that or suggesting that it didn't exist, essentially.
Discord, Southern discord.
Your Honor, there was no such insinuation that it didn't exist. So that's number one. It's still hearsay. It's duplicative of her testimony and all the previous objections that Mr. Rogers lodged. And it goes beyond, I'm sorry, Your Honor. It goes beyond my redirect as well. I mean, my cross-examination.
And also, how is this not bolstering? How is this permissible bolstering? She testified to what she recalled happened, I think it was a year before.
Yes.
So, I'm sorry. She testified to what she believed happened to a year before. Why are we allowing in her written statement, her redacted written statement about that?
Because defense counsel asked whether she gave it to the schools and whether it still exists.
Wait, I need to rewind that because I totally scrolled this because I was reading Cindy's comment. I spent years evaluating children ages 2 months to 5 years to try and catch physical development and psychological delays to offer services and support. You'd be amazed at how many parents refuse. You know, I think back here, I'm gonna put me on screen to talk for a minute. And I think back, you know, if I had gotten help, I probably wasn't ready for it. You know, I was doing my own thing. I was fucked up in my own way. And if I had gotten help, things might have been different, but I wasn't ready for it. So, you know, refusing it and then ended up in turn mentally messing up my child because of my own mental health issues until I got him in check. So, you know, there's a little bit of mental health story for you. You know, it's a lot. It's a lot. And if you're not willing, you as an adult, capable adult, totally capable of doing it with a child, no less, and you don't do it. Muffins was too young. She was too young. So yeah, she was too young. And I can tell you that I had a mental breakdown, and I can tell you that she pulled me over into a gas station. Didn't know how to drive, but she reached over and helped mommy steered the car into a gas station and went and called her aunt on a payphone, no less. And that's when I got help. So, until you get to that breaking point, sometimes it's hard. Sometimes it's really hard. So, and I think about these parents, and I guess that's why I'm reflecting and thinking, because I think about these parents and it's like, well, why didn't they get help? Why didn't they do this? And why didn't they do that? And then I have to step back and think about when I was in my 20s doing the fucked up shit. You know what I'm saying? Total side rail there. And I didn't mean to go totally off the wall, but I'm just saying that as parents, we sometimes have to learn. And God, I hope these parents have learned.
And I'm establishing that it does.
I was so total squirrel.
Okay, so
Sorry.
you're interpreting
Going back to
that
my
as
corner.
an attempt to impeach, and so you're trying to rehabilitate?
There's if the objection is hearsay, there's an exception to that. If we want to talk about why it's relevant at this stage, yes, we can go to the relevance rules and find that a prior consistent statement does become relevant when on cross-examination, or does become admissible when on cross-examination the witness has been challenged as to having a memory or forgetting something. I can find the rule.
And again, I understand that's where the impeachment can come to, but that's the missing link for me. So, the thing, it does not come in, and you may approach to retrieve the document.
Thank you, Judge. So thank you. I don't have any further questions for you.
Anything further? Okay, and the status for this witness? May she be excused?
I'd ask that she be released unless I'd ask to be released.
Oh, and no objection from defense. Okay, so that means thank you for your testimony today. You are released as a witness. You don't have to go back to that room. You do not have to stay in the courthouse. You are welcome to remain in the.
Raise your hand, sir. Do you swear or affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth?
As you need.
Okay, sir, get up there and get comfortable. Oh, he's easy on the eyes.
Good afternoon.
Hi,
Would you
sir.
please tell us your name?
Alonzo Walls.
Mr. Rawls, just a quick reminder that we're not using the names of any children today in court. We'll use initials in place of that. Mr. Rawls, in January of 2023, how were you employed?
I was a school counselor.
Where?
At
Hannah.
school at Richmond Elementary.
All right. And how long had you, as of the January 2022 or 2023, I'm sorry, how long had you been at Richmond?
It probably would have been between that time, it'd been like a year and a half.
Okay.
Not quite 2 years.
And during the course of your time at Rich Neck, did you come to know a student who we'll refer to as JT?
Yes.
And in the course of your duties, did you receive an assignment related to JT?
Yes. In his second year at Rich Neck, I was assigned to kind of be like his one-to-one within a set schedule.
How did that assignment come about, if you know?
I don't recall in its entirety. I do believe that originally, because he was having some issues, they were trying to put a plan in place to help him to adjust into the school and be more productive. So I believe the administration came with a plan up, and they administration need to help him out with that plan.
Tell us how, if you could, just describe for the jury how the one-on-one assignment worked. What did you do?
Well, in the morning when he got off the bus or was dropped off, I would proceed to have like a morning session with him, kind of set goals and plans for him in the morning. He would then go to one of the, I believe it was one of the SPED teachers to kind of reiterate those plans. After that, he was working with Mrs. Kovac on some it was like reading assignment. She was a reading specialist at that time. And then when that point, after her time was up, I would come back, retrieve him, and I would take him to the classroom. I would be with him in the classroom.
Okay. And did you ever speak to Dr. Ebony Parker regarding this assignment with JT?
My recollection, I don't recall. I just remember this is when they were requesting that.
Okay. Do you know of any behavior issues that JT exhibited?
Yeah, his first year there, he exhibited a variety of different behavioral issues where he was out of the classroom or taken out of the classroom for whatever case may be, but it varied from time to time.
Okay. Mr. Rawls, do you know what an SST is?
Yes.
Okay, what is that? Can you tell us?
Student support team. It was basically a process or a program to put in place to help to assist them in trying to, once again, be more productive in the school system.
And did the SST plan involve regular meetings?
Yes.
Did JT have an SST plan?
They were in the process of moving forward with SST because
I'm listening to this and I'm kind of amazed. I knew that they had like individual people that help the children, but I've never actually heard somebody speak. I've never known actually what they do. So this is interesting. My headphones died.
I believe they were trying to transition that SST into more like an IEP, which is like a more specialized support system for students, and it's called the SPED system.
Okay. And who all was involved in the SST process for JT?
I was currently at the time under the Purdue's public schools and policies. Counselors were one of the main people that ran the SST process. Administration would be involved when they weren't available and things of that nature, but it was more so put on responsibility of the counselors.
Okay.
Coordinate the SST meetings.
And so at those SST meetings, who would typically attend JT's SST meetings?
It would be either the principal, the AP, myself, or another counselor, a parent, and if they had any advocates as well, they would be willing to be part of the meeting. That's how the kind of group of people would be.
Were parents and guardians of children invited to attend those as well?
Yes, of course, yes.
You've mentioned principal and AP. What's AP?
Oh, assistant principal.
Thank you. And as of JT's SST, who was the principal at the time?
During the time, the principal.
I'm sorry, I put you on the spot.
I can't remember.
Okay, do you remember who the assistant principal was at that time?
Dr. Parker was the principal during the SST process in that second year, yes.
Okay. Did Dr. Parker sometimes attend the SST meetings, if you know?
I believe she may have attended some, yes.
Okay. Did there come a time when you decided you no longer wanted to, or maybe that you no longer thought it was useful to have that one-on-one assignment?
Yes, because.
Hold on just a moment.
Okay, what happened? I heard something. Object leading. Okay, response.
I'll rephrase the question.
Thank you.
Did you ever decide that you did not want to continue the one-on-one relationship with JT?
Okay, same objection? Response?
I asked, did you ever decide that you didn't want to continue the one-on-one relationship with JT? He's already established the foundation that he had the one-on-one assignment. And did you decide is a question he can answer yes or no? He did decide it or he didn't. I'm not suggesting which of those answers is the right one, so it's not leading.
Okay, I think the leading part is to just continue the relationship with JT. So I think the proper phrasing would be, did you decide whether or not to continue or discontinue a relationship with JT? So if you could ask that, or do you want me to just?
Go ahead, Judge, if you would like to ask the question.
Did you get the question?
Yes.
Okay, you can answer. Thank you, sir.
I'm sorry.
It wasn't a decision of sorts. It was a request. As a school counselor at that time, I had many students that I had to serve, and I felt like it took away my opportunity to service a lot of the other students within the building. So I had requested if I could be relieved of that duty so I could also service the other students besides I could still assist. I heard it needed to be done with JT, but I also want to be able to service the other students in the building as well.
Thank you. During the time that you were working one-on-one with JT, did you experience behavior issues or witness behavior issues?
Can you repeat the question?
During the time you were working with JT, did you experience or witness behavior issues?
When we were more one-to-one, it tapered off more. He still had concerns here and there, but he knew so that he needed one that I would be there to help to correct or redirect a lot of his behaviors.
And what were the behaviors that you observed of JT at any point that year?
Non-compliant, defiant behavior, refusal to do work, just acting out of sorts where he wasn't following directions, things of that nature.
Would those issues ever be discussed at the SST meetings?
I mean, how often do we hear the attorney or the prosecutor tell the judge, just go ahead, judge, you ask the question? I mean, that just was like, I don't know what the process is. Who's doing what? Who's on first? We have two defense lawyers tag teaming questions. This is crazy. This is nuts.
I'd like to take you to January 6th of 2023. You remember that day?
Yes.
What is the first moment that you realize something might be up with JT?
Objection, leading as soon as facts and evidence.
I'll rephrase. On that day, did you ever notice anything unusual about JT?
On that day, I didn't even really witness him that day until later. That was in that evening of the afternoon of the show of that day.
Okay. Did you eventually become aware of a crisis that occurred that day?
It was brought to my attention that after dealing with another student, that something had took place at recess where JT apparently told another student something.
So I understand it's hearsay. Let me walk through that with him. During the day on that day, did you have occasion to speak with any students?
Yes.
And were there any students who shared a concern related to JT?
Yes.
Now, without telling me what the student said, could you describe the student's demeanor, how they appeared at the moment they were telling you the information?
They were very emotional, very sad.
Okay. Again, without telling us what was said, were they referring to something they had just experienced or seen?
I wouldn't say they just experienced it, but they experienced it in an earlier time where they still holding on to that it was stated.
Okay. And with that information, without...
If this man don't stop scribbling in my ear every time he marks off a damn question that he asks, I hear that pen. I'm like, what the? I'm going to break his pen in about 5 seconds. He does that again.
Again, without telling me what was said, with that information, where did you go?
With that information, where I went is I went to Dr. Parker to address the allegations that I had heard.
Okay. Did you ask Dr. Parker to take any action?
I didn't ask her to take any action. It was presented to me to get some action, but taking it at a particular time with something else. And then I requested her if I could take some action.
Okay. And what action did you ask Dr. Parker to take?
I asked her if I could take action of trying to search or to check the person about JT.
And what did Dr. Parker say anything?
She responded by saying that at the time, because of the scheduling he had, his parent or parental guides would be coming to get him so that we could hold off at that time.
Okay. The concern and the desire to search JT, did you share your concern without telling us what was said? Did you share your concern with anyone else?
The only person that's our concern, I shared my concern with is when I went back to speak to Mrs. Zwerner after I spoke to Dr. Parker.
Okay. Mr. Rawls, at the time that you asked Dr. Parker for permission to search the person of JT, did you believe that you had the authority to do that without an administrator's approval?
You know, in my previous experiences, you just can't, in my position, you just can't search a student without some type of permission.
Okay. And finally, Mr. Rawls, as you sit here today, do you wish you had done differently that day?
Yes.
Okay. Thank you. I don't have anything further.
What the hell just happened?
Better, is that correct?
I would say yes.
Permission to search the person of.
Good.
Hey, we have Mr. Clean doing it.
So
yes, Cindy. It's
on
like
January
right
6th
there.
of 2023, you were the school counselor at Rich Neck, is that correct? Okay. And
Here, I'll put me in the back so you can see his name for a minute.
at some point, was it at the very beginning of the year, did you assume the responsibility of having the one-on-one contact with JT?
Not necessarily at the beginning of the year, no, sir.
Okay. But at some point you began one-on-one contact with JT, is that correct?
Yes, sir.
Okay. And how were your initial interactions with JT? Were they positive, or was it a challenge?
At times it could have been a challenge, but we built a rapport from the year before where it wasn't as difficult for myself.
Okay. And so over a period of time, his behaviors began to get better. Is that correct?
I would say yes.
Okay. And you were part of the SST team. Is that correct?
Yes.
Okay. And you function as the counselor as a part of that team?
Yes, counselor.
Okay. Would you say that you were in a pretty good position to assess how JT was doing on a given day?
I would say yes.
Okay. And would you say that you had more contact or less contact with JT than Mrs. Kovac, the reading specialist?
I would say we probably had about
the same amount of time? Okay. And at some point, you indicated that you requested less one-on-one time with JT?
Yes.
But it didn't sound like it was because he was doing better, but it's because you wanted to be able to help more students at the time. Is that correct?
Yeah, from my point of view, is to be able to get more successful students.
Okay.
Okay, if you could speak up and tap that microphone, let me see if it's on. Okay, talk into it so that the reporter can get your words in. Thank you. So if you repeat your answer.
Oh. Can you repeat the question?
So you got to the point where you were spending less time with JT. The motivation for that was to be able to spend more time helping, I guess, more students,
yes.
More people than just JT. Is that correct?
Yes.
Okay. All right.
Go ahead, and I know we're hearing that mechanical squeaking now. We think it's a chair. So just, well, you know where it came
No, it
from?
wasn't a chair. It was a voice or something like that.
Well, do you know where it's coming from or feedback?
It seemed to be from my right.
Oh, okay. So again, there are other courtrooms and other lockups. We can't do anything about that noises. I'm sorry. Just ignore them. These things on the wall, these are sound panels. So we have as many as we can have, as you see, to absorb all the sound. So we'll just have to do our best to move forward.
Thank you, ma'am.
Okay,
I
repeat
understand.
your question, please.
So my next question is, do you, when you began to have less contact with JT based on your request, did you think that was a good move for JT? Do you think that may have been detrimental to his progress?
I can't really answer that.
Okay. But based on your position, you thought as far as resources, you needed to have contact with more students. Is that correct?
Yes.
Okay. Maybe it's that's what it is. That's what it is.
Okay,
So I'm the source of the distraction.
All right.
You mean to tell me this whole time, he been squirreling about this sound and he's been the one making the damn sound? Can you shut the fuck up for a few minutes? Mommy's trying to talk and you're not getting any. You know what? Y'all want to know what his problem is? Look, I went and got me a piece of my lemon pound cake. Okay? He's mad. He want my... But I'm going to rewind this just a second because y'all see what just happened here. Stop. You're not getting any.
You thought as far as resources, you needed to have contact with more students. Is that correct?
Yes.
Okay. Maybe it's that's what it is. That's what it is.
Okay,
So I'm the source of the distraction.
All right.
What a ding
So
dong.
after you decided to have less time with JT, did you notice any kind of degrade or in his behavior?
Not necessarily, because another plan was put in place to kind of almost say replace me, but to try to subside.
Where'd you go? Come here.
Describe that go around or that next plan.
But the next plan, from my understanding, was that authoritative figure within his family would be able to come in to assist and support him in his times process.
Okay, and so you actually observed that next phase of the plan with JT. Okay, and did that next phase seem to cause improvement with JT's behavior?
As far as I know, once again, once I was alleviated from that, I wasn't so hands-on, but I would say it seemed like he was kind of improving, yes.
Okay, so were there less calls from a teacher or from an administrator for you to respond to JT due to bad behavior?
On my understanding, yes. There was less calls to me, yes.
Okay, all right. Now let's talk about January 6th. Did you have contact with JT on January 6th of 2023?
Later in the afternoon, yes.
Okay.
Not like direct contact. I observed him.
Okay. You said
Observed
not direct
him?
contact, but you actually observed him. What?
Right,
So
Hannah?
as a result of hearing information, you decided to go and place your eyes on him. Is that correct?
Yes.
Okay. And when you placed your eyes on him, was he in the classroom or was that on the playground? Where was he at? In the hallway?
I placed my eyes on him, he was in the classroom.
Okay. And when you placed your eyes on him, did his behavior that you observed, did it cause you concern?
No.
Okay. Did he seem like it was JT, his normal behavior? Is that?
Actually, it seemed abnormal behavior. He was way calmer than he normally was.
Oh, okay. So
interesting.
Pretty calm. How long did you observe him?
It was a few minutes. It was long.
Okay. And during that few minutes, JT was doing okay. Is that correct?
Yeah.
Okay. And is it safe to say that you may have had some concerns for JT's safety or anybody else's safety, and that's why you wanted to put your eyes on him. Is that correct?
Well, not at that time. At that time, like I said, it was at normal court that they were being that calm in that setting.
Okay.
But I didn't have any concerns of him.
Okay. So you put eyes on him, and you were satisfied that JT was doing well that day. Is that correct?
Yeah.
Do you and did you have contact with him directly or indirectly after that?
No, I did not.
Okay. So you did not observe any behavior of JT on that day that made you believe that JT presented a threat of danger or harm to any of the students. Is that correct?
That's correct.
Okay.
Right, Hannah?
I believe through the questioning, it seemed like there may have been an indication that there was some additional feedback that you received. Is that correct?
Yes.
Okay. Did that cause you to need to put your eyes on JT again?
The initial feedback that I received had me concerned about what was being said, and that's when I wanted to address it with Dr. Parker and things of that nature. The only other time that I saw JT, and I don't even recall really seeing him, particularly when I went back in that classroom. I don't remember actually seeing him at that time.
Okay. Okay. And do you remember the timing of that when you went back into the classroom?
Once again, it had to be between the hours of 12:45 to 1 something.
Okay.
But I don't recall the exact time.
At any time did you feel like that you needed to step in and pull JT out of the classroom?
Only time that I felt like I heard the feedback that I would receive, and then once again I was told to hold off on that.
Okay.
Right.
Did you agree with that decision?
At the time, I felt like it was the decision that was made, and whether I agree with it or not, I was just there to be a support. When I came back to the classroom, I spoke to Ms. Zwerner, and I told her what was said, and I told her that I would be there if she needed me.
Okay. When you left Ms. Warner, did you feel like you were leaving her in extreme danger, or the students in extreme danger?
No.
Okay. When you walked away from that class, you were at peace with JT's behavior, what was going on in the classroom. Is that correct?
Yeah.
Okay. Now, so when the actual incident occurred,
But was he aware of everything that they had all been saying about the two girls and all that stuff? I mean, this is weird.
you immediately think that, oh no, JT has shot somebody?
No, when they went into lockdown, I thought it was a drill initially.
So you were shocked that the incident actually occurred. Is that correct?
That's correct.
Even with the earlier feedback that you received, is that correct?
That's correct.
Okay. You did not think that you needed to take any action to prior to the incident to separate JT from the classroom. Is that correct?
That's correct.
Separate his classmates from him. Is that correct?
That's correct.
You didn't feel like you needed to call the police? Okay. All right. If you believe that there was a gun, do you understand that it was your responsibility to separate JT from the classroom?
Yeah, I mean, that was your responsibility.
Okay.
It was.
Okay. And it would also have been your responsibility to contact authorities. Is that correct?
Correct.
Okay. You had been involved in previous incidents when JT was removed from the classroom. Isn't that correct?
Yes.
Okay. Just a couple days before that. Okay. You were involved in that incident.
Yes.
Okay. You removed him from the classroom?
Yes.
The incident wasn't something that caused danger or harm to his classmates. It's a cell phone was broken. Is that correct? And that resulted in him being taken to the office. Is that correct?
It's like, it was just stuff a little bit of nature.
Okay. So, as a staff member, even on that day, you understood it was your responsibility, if you thought that there was a threat to the students, to remove the threat or the students from that danger. Is that correct?
Objection asked and answered.
Yeah, that's fine. You want to have a moment?
Yes, ma'am.
fine. Okay, Teresa. Thank you. Just let it play. Go be annoyed. Go chase a dog, run around the block. I don't know, because I feel like I'm going a little loony over here. Yeah, what are we waiting on?
Briefly, yes, Judge.
Yes, sir.
Just so that I understand the timeline of events, you testified on cross that you went and put your eyes on JT. Do you know if that was before or after you spoke with the student and it caused you to go to the assistant principal?
No, before.
It's before, okay. Do you know roughly how long before you spoke with that student?
I do not recall.
Okay. Would it have been more than 2 hours?
It was earlier that day.
Okay. And what were the initials of the student that you spoke to?
I don't remember the first initials are.
Okay, thank you. I don't have any further questions, Judge.
Anything further from the defense for this witness?
Yes, Ma'am, Your Honor.
Hello, Mr. Ross. You just mentioned speaking with a student with the first initial of R. Did you ever tell Dr. Parker what R has said to you?
I believe I mentioned what he had mentioned to me, yes.
You believe you did. Do you know for certain whether you did? Okay. Would you be surprised if you did not do that?
I would be surprised.
Okay. No further questions.
Anything further from the Commonwealth?
Judge, based on that, I'm going to need a couple of minutes
Okay.
before redirect, I guess.
All right. So we'll take this is a good time for stretch break and after lunch restroom break. So it's 3:25.
Okay. Sorry, I was reading something. Okay. Take a break. Low. Low.
We can bring jurors back.
Oh. Wait.
Yes, News, you need to come and connect.
Wait, look who we got. Hi. Hi, buddy. He never comes and visits mommy anymore. Hi, buddy. Hi. I don't have any more pound cake. Y'all ate it all. I'll give y'all some more later. Quit. You say hi. You say hi. Meet, say hi. And look, I'm being shoved because guess who's trying to get over here too? Say hi. Meet, say hi. Meet, say hi. Meet never comes up anymore. I know. We're just getting love for a minute. Okay, y'all go play now. Go play. Go. Mommy's got to get back to court. Y'all are too much. Mommy's almost done. It's almost over and we'll go play. Okay, mommy's gonna hit play.
Audio. Please come on up.
I can play in a minute.
Thank you.
I got this one.
You got that one. What about the other one? You said this one. Okay.
Yeah, I tried most of them.
Yes, all day we pay cheese tax. Jealous.
Please rise for the jury.
Jealous? I told y'all, jealous. Stop. Y'all behave. Jealous.
14 jurors.
Quick, go play.
You go on and have a seat, thank you. You may resume your redirect. I'm sure I'll be
This is redirect. Yes, be quick. Mr. Rawls, thank you. I believe you indicated to the defense counsel that you didn't remember what you had told or whether you told Dr. Parker about the incident at the time you asked for permission to search the backpack. Is it true that you don't remember that? Sure. Understandable. Did you give a statement to police in this case?
Yes.
And if I were able to provide you with a transcript of that, might it refresh your memory about what you said to Dr. Parker? Okay, may I approach, Judge?
Yes, and you responded yes, correct? Yes. Okay, he nodded his head, I just want to make sure it was recorded. Yes, you may approach.
No, go play.
I'm just going to give you this document to take a look and read there. We're at the pink post-it note, and after you're done reading, look up and I'll ask you a question.
That's it.
Hold on, don't read it. Yeah, sorry. Read it to your. Just read it silently, and then I'll ask you a question about it. Sorry. And does that refresh your memory about what you said to Dr. Parker regarding the incident?
To an extent, yes.
Okay. Would you just tell us then what it was you said to her?
I'm looking at the witness. At this point, he looks like he's looking at the page, and he's going to be looking at the page and then advising. So his memory has been refreshed.
I'll take it back.
Okay.
Are we really doing this? Children. Oh, they scare. I'm sorry, Cindy. No, they're so jealous. They do this all the time. One gets too close. Lola don't like it. I'm used to it. They get mad. They have their little spats. I'm sorry. No, they're fine. They their lovers quarrel. They'll lay on the bed and they'll do the playing, and then they get mad just like everybody else. So y'all here in this court, they're having this big shindig problem about the fact that they left that paper up there, and he wants that paper. The other one says, no, y'all got to take that paper down. Y'all got to take it. He can't look at that paper and give his opinion. Stop. Go play. You don't want me to make you kennel, do you? You want to go kennel? I'm almost done.
Yes.
Okay. Would you just tell us then what it was you said to her?
I'm looking at the witness. At this point, he looks like he's looking at the page, and he's going to be looking at the page and then advising. So his memory has been refreshed.
I'll take it back.
Okay.
I'll go get it.
So what's your
May I approach?
you just like him to.
I want this done properly. Yes, Your Honor.
Yes, may I approach?
You may approach.
Thank you.
And ultimately, for parties, the legal principle is you can't read from that statement. You can refresh your memory, but you need to testify from your memory.
So he looked at it, he read it. Now let's take it away and make sure he remembers what he read. And oh my God.
Okay.
Based on now that's refreshed, if he has an independent recollection.
Well, he said to an extent, so
He did.
flush it out.
Yes,
and
indeed.
we'll give you the opportunity to cross. Go proceed, Mr. Jenkins.
Having refreshed your recollection, do you remember what you said to Dr. Parker prior to asking to search the backpack?
I'm almost done. Go play.
It was already relayed to me that a book bag was searched from JT, and then nothing was found within the book bag.
Do you remember if you confirmed with Dr. Parker that you and she knew what you were talking about? Or who?
I know enough that we confirmed that we thought something may have been in the backpack, yes.
Okay, thank you. I don't have anything further.
Y'all quit.
And
Y'all lay
Mr.
down.
Rawls, and from what you just recounted, nothing was in the backpack, correct? It had been searched and nothing was there, correct? Okay. And at that point, you did not believe there was any credible threat, correct?
Objection asked and answered on recross.
No, I'll withdraw the question, Your Honor.
All right, thank you. All right, anything further for this witness?
No, Your Honor.
All right, and the status for Mr. Rawls, may he be excused of this, need to remain.
I'd ask, oh, I'm sorry.
No, I'll
I'd ask that he be released.
Oh, no, we're going to ask that he be released.
So we're going to ask
Oh,
that he be
shit.
I agree to that. We'll ask that he be constructively sequestered, remain available for recall.
Okay, are you, is that suitable to the defense?
Yes, sure.
Okay, and do you all have his phone number?
No, come on, Captain.
Absolutely, I do.
no.
Happy to facilitate that happening.
Okay, so Mr. Rawls, what that means is you are still a witness. You still have the ability to be recalled. So do not discuss this case, do not discuss your testimony, but you do not have to stay in the courthouse, you do not have to stay in the witness room. You can leave and go about your daily business. You will either get a phone call, 1, to come back to the courtroom, or 2, that the trial is over and that you are no longer a sequestered witness. All right, any questions, sir? All right, thank you, you may step down. Next witness.
Megan De Leon.
Megan De Leon. That door slams loud.
You're about to take this the truth. Take the witness stand, watch your step. All right, you may proceed.
Good afternoon. Would you please tell us your name?
Megan Dillion?
Ms. Darion, do you have a daughter?
I do.
I want to just caution you, and I know we've discussed this, but during the course of this trial, we're not using any children's names, only using initials or referring to your daughter if you prefer. Back in January of 2023, was your daughter attending school?
Yes.
Where?
Rich Neck Elementary.
Is that here in Newport News?
Yes.
And what are your daughter's initials?
SD.
On January 6th of 2023, did you become aware of an incident that caused you to go to the school early?
Yes.
And when you got to the school, did you immediately see SD, your daughter? Do you eventually see her that day?
Yes, when they bring her out to me.
Okay. When you first see her, describe, without telling me anything she said, just describe her demeanor, how she appeared to you and how she interacted with you.
I'm waiting for the question. Do you have a civil suit against Miss Ebony Parker? Hannah, I think it is. I think it absolutely is. Okay. Lola might bark a little bit. I sent her to the other room. Meat's laying down on the couch, relaxing, and she was over here harassing him. So I got up and I put her in the other room and I locked the gate, and she's a little angry.
Initially, she just seemed happy to see me, her dad. It was later on in the evening when she kind of showed different behaviors.
By different behaviors, you mean different than prior to the events of January 3rd? Describe what behaviors you observed.
Just that evening, it was a very hectic day, so we just ordered a pizza in and just tried to put some show on to kind of. But the doorbell rang just for the pizza, and she just got very scared and jumped from her seats. The sound of the doorbell and other sounds like that for many months to come just scared her.
What kinds of sounds would scare her?
Slamming of the door. I know just loud bangs. She described the sound as a ladder falling when the gun went off. So loud sounds have startled her.
No, I'm going to object to her statement. Sounded like
I knew he was going to object to that.
Sounds like she's testifying as sickness that Stephen had stated. If that's what she has done, I'm objecting to the hearsay.
If the request is to strike sounds like a ladder when the gun went off, I agree to that.
Okay, so struck, don't consider that, please. Next question.
So what other behavioral changes, if any, related to SD did you notice in the immediate days and weeks?
Not understanding why this happened. She loved her teacher. The teacher was kind, and she didn't understand why anyone hurt her.
And who was her teacher, if you know?
This morning.
Okay. So Ms. Zwerner, was Ms. Zwerner's classroom her homeroom?
Yes.
Okay. As a result of what you observed with SD, did you seek help for her of some kind?
Yes. We went to just regular counseling through our insurance, and then also spiritual counseling through my church.
And how long did that go on for?
6 months.
Response.
These are the injuries that the neglect caused, the trauma to the children, and I believe that that is relevant.
So I'll allow it, but do you have additional questions down this line, or do you have additional questions in this line of questioning?
Only to elicit any additional different things that she noticed in her daughter. That's it.
I'll allow it, you may proceed.
Okay. We're from January 3rd to present. Any additional things you've noticed in your daughter that were not present prior to the January 3rd incident?
She's very, she doesn't want to talk about it. She keeps everything close hold. She holds in a lot of feelings and emotions. Recently, she went back to counseling. This is the time they said to start doing, to give her some time and re-engage with the counselor. And they said that she has depression, anxiety, and one other thing where she goes on alert.
All right. Thank you. I don't have any more questions for you, but thank you.
Good afternoon, Ms. DeLeon. You were never inside of Rich Neck Elementary School on January 6, 2023, correct?
In the building? No.
Okay. And you did not encounter your daughter in the building, correct?
Right out front. No, they right out to me.
Okay. You filed a civil lawsuit arising from the events of January 6, 2023, correct?
Yes.
In this courthouse, correct?
I predicted the future. I predicted the future, y'all. I predicted it.
In this courthouse, through Newport News, yes.
Okay.
What do you mean by that?
There's a pending lawsuit in Newport News Circuit Court, correct?
Yes.
Okay. And you've named Dr. Parker as a defendant in that case?
Well, I prefer not to talk about my opinions of the case.
Well,
I'm going to object, Judge, and ask that we not talk about a child's civil matter on TV, that we have not continued the broadcast while she's speaking about the civil suit that
has gone
is her
crazy.
child's, really, not hers.
The court's ruling will be the same as earlier, so the objection will be overruled. She's been cautioned that we're only using initials, but the Question party has a right to cross-examine about interest in case. And if you just ask who the main parties, not what your opinion is. But I think you said I prefer not to share my opinion on it. So non-responsive as well. Repeat your question, Mr. T.
Thank you, Your Honor. In that civil lawsuit, you have named Dr. Parker as a defendant, correct?
Yes, please.
Okay. And you are seeking money damages from the defendants in that case, correct?
I'm more seeking justice for my daughter and what she went through.
And you are seeking money damages from the defendants in that case, correct?
Yes, there is some discussion with that, yes.
Yes, but the loss, I know there are settlement discussions, I'm sure there are. But in terms of what you're asking for in that lawsuit is money, correct?
Yes.
Okay. And you believe that a criminal conviction of Dr. Parker would help in that case, correct?
I don't have any opinion about that or anything to say about that.
Okay.
Right.
After January 6th, you requested that your daughter be transferred to a different school, correct?
Yes,
And that request was refused by Newport News Public Schools, correct?
it was.
Okay. No further questions.
Thank you. Anything further from the Commonwealth?
No, Your Honor.
All right. And the status of this witness?
We'll ask that she be released. And we're also calling Nicholas De Leon.
Any objection from the defense to this witness being released?
No, Your Honor.
Okay. Thank you, ma'am, for your testimony. You are released as a witness. You are welcome to remain in the courtroom, or you may leave the building. Thank you. And the next witness's name again, I'm sorry.
Nicholas De Leon.
Okay, Mr. De Leon, please.
Here we go, guys.
I'm going to object to the testimony of the next witness because I believe it's cumulative. I don't think that he will be able to testify to anything other than his.
I didn't know it was going this way. I just knew that it was.
So, okay, tell me why it's cumulative.
How's it walk?
Wait, I didn't know it was going this way. I just know that I thought this was the last person on the stand. I didn't know it was going this way, so I'm a little dumbfounded right now. Right? Me too, Cindy. Do they all have the same civil? Is it a civil lawsuit? They're all in against her. I might have to look it up. I might look that up because now I'm curious. Okay, let me hit play on this. Let's see. Oh, something just happened, and somebody's saying it's cumulative, but because somebody else is testifying.
Because I believe it's cumulative. I don't.
Thank you. And the next witness's name again, I'm sorry.
Nicholas De Leon.
Okay, Mr. De Leon, please.
Your Honor, I'm going to object to the testimony of the next witness because I believe it's cumulative. I don't think that he will be able to testify to anything other than his.
I don't know who they are. So, okay, tell me why it's cumulative.
How's it walk?
Mother and father of the child.
Okay. It's just one witness. I'll allow. I mean, are you bringing out 5 relatives at the same time?
Absolutely not, Your Honor.
Okay,
Absolutely
you
not.
come out overruled. Mr. De Leon, please.
He's throwing a fit because the mom and the dad. But oh, jeez.
Do you swear from the testimony you're about to give is the truth, whole truth, and nothing but the truth?
Yes.
Please take the witness in. Watch your step. Chair and microphone are adjustable. You may proceed.
Good afternoon, sir. Would you please tell us your name?
Nicholas DeLeon.
And Mr. De Leon, just a reminder that we're not using the names of any children at all, including your own. But do you have a daughter?
I do.
And what are her initials?
SD.
And where did SD attend school?
Richmond Elementary.
Okay. And are, as of January 3rd, 2023, were you, let me ask the question like this. Who is SD's mom?
Megan De Leon.
Thank you. Between the time of January 6, 2023, before and after, were there any changes that you noticed in your daughter SD after that hadn't been there before?
Yes.
Could you just describe what you personally noticed or observed, but not anything that she said to you?
I noticed that she was anxious, depressed, very not like herself, as in being quiet, distant, couldn't sleep.
How long did that persist?
Quite some time.
Okay.
Months.
Did you and her mom seek any sort of treatment for her?
Yes, counseling is for counseling.
Has it helped?
I think it's hard to say at this point. She's still going through counseling. It's been up and down, I think, with her.
All right. And just to confirm, whose class was SD in?
Wonders.
And was that at Rich Neck Elementary?
It was.
All right. Thank you. I don't have any other questions for you. Please answer any from defense counsel.
Okay, here, let me be that smart ass. If it's cumulative, then why bother asking him questions? Just say, I have no questions because I asked his wife everything I need to know. I'm a smart ass today.
Good afternoon, Mr. De Leon. All right, you mentioned your daughter SD. You don't have any knowledge of whether SD was in the classroom when Ms. Zwerner was shot, do you?
I was not there in person, but that is her classroom.
I understand. But you don't have any idea whether she was actually in the classroom, correct?
From what I understand, that she was in the classroom.
And what are you basing your understanding? Is that from somebody told you?
Again, I was not there.
Okay.
I can't verify that. But
So you can't verify that. I'm not asking you to tell me what you were told. That's hearsay. Okay. Now, you are aware that your wife, or I don't know the status of your relationship, but Megan De Leon has filed a lawsuit on behalf of your daughter in this courtroom, correct? I mean, this courthouse, correct?
Yes.
Okay.
He could have said the mother of your child.
Okay. And that you're aware that Dr. Parker is a named defendant in that lawsuit, correct?
That's correct.
Okay. And you're aware that money damages from Dr. Parker are being sought in that lawsuit, correct?
Correct.
Okay. And so you have a financial interest in a criminal conviction of Dr. Parker, correct?
I don't. This is on behalf of my daughter.
Oh, so you believe your daughter has a financial interest in the conviction of Dr. Parker?
Today, that's a separate case.
Just answer my question.
That's a separate suit.
Answer my question. Do you believe that your daughter has a financial interest in the criminal conviction of Dr. Parker?
Today, I don't believe so, no.
Do you believe that a criminal conviction of Dr. Parker will help in that civil lawsuit?
Objection asked and answered. He said no.
No, it has not been asked and answered, Your Honor. I asked a different question.
Well, it's a different question, and I think you already answered it. Are you asking his answer to be struck?
Yes, it's irrelevant and duplicate.
Overruled, and your answer was no, sir, if I heard you correctly?
Correct.
Okay, thank you.
No further
Questions?
No further questions, Your Honor.
Any redirect?
No, Your Honor.
And status of this witness?
I would ask that he be released.
Any objection?
Whew.
Okay, thank you, sir. You excuse me. As a witness, you may stay in the courtroom or leave, as you see fit. Next witness?
Commonwealth will call
Oh, there is one
Tanisha
more.
Richardson.
There's two more then, because there's a strange looking guy. There's a guy that they were making fun of him when I was looking in the chat. They were making fun of him, which was stupid, but just because he looked different. I hate that kind of stuff.
With the truth, whole truth, and Foster Step, and the chair of my Colorado Justice.
Good afternoon. Would you please tell us your name?
Good afternoon. My name is Tanisa Richardson.
Ms. Richardson, do you have a child?
I do.
And in January of 2023, was your child in school?
Yes.
What are your child's initials?
KS.
All right. And just as a reminder, we're only using initials, not names today. Where was your KS in school?
He was in his classroom. He was in first grade in his swimmer's class at Richmond Elementary.
All right. And did there come a time earlier than normal on January 6, 2023, when you had to go to the school, Rich Neck, to pick up KS?
Yes. I received notice that there was a community post on social media that there was a heavy police presence at the school.
Okay, let me stop you there. Let me, you're okay.
She
Just
found out
let me
through
ask you
social
questions and
media.
I'll walk you through it,
Get
okay?
out.
So after you saw what you saw online, did you go to the school?
I did.
Were you eventually reunited with KS?
Yes.
Could you describe, without telling us anything that he said, could you describe his demeanor, how he appeared to you when you first saw him?
He was very tired. He was cold. And he was ready to get home. He was just really exhausted from the day.
Yeah.
I bet.
Did you notice any changes in his behavior after January 6th of 2023 as opposed to before?
Yes.
I want you to just describe what you were able to notice as his
texting me.
parent that changed after January 6th, 2023.
Caden experience. Oh, sorry.
It's okay, I understand.
Experience.
And the news is directed to Bill feedback, so it's not going to go out to the press. I just wanted to assure you, we will catch it.
Thank you. I'm sorry. Airway, stomach aches, headache.
Boy, that was a fail, wasn't it?
Just a general anxiousness, just extreme fear, as well as hypervigilance.
When you say school avoidance, can you kind of describe to me what that means?
He was literally afraid to return to school.
How long was he afraid to go to school?
I would say until at least the end of the school year of that year.
Okay. Did you seek any type of treatment for KS?
I did.
Okay. What did you seek?
He actually had a psychologist initially, and then he also attended CBT therapy with a counselor weekly.
And how long did that go on, and is it still going on?
I would say it lasted about 1.5 to 2 years, and we've stopped it since then because his therapist went to a new practice.
Okay. Do you think that it has helped KS?
It has helped.
Good. Thank you. I don't have anything further for you.
Please don't tell me that he's going to say, "Are you in a civil lawsuit?" Oh, please don't tell me that.
Good afternoon, Ms. Richardson.
Good afternoon.
You currently have a civil lawsuit pending in this courthouse, correct? Regarding the incidents of January 6, 2023?
Yes.
Okay. And you've also, in that lawsuit, you've named Dr. Parker as a defendant, correct?
Unfortunately, I'm not. I don't feel comfortable discussing the details of that in this arena.
Your Honor, I'm just going to renew my prior objection. I understand the court's rule on the issue.
So the court will overrule the objection. It's appropriate to be discussed. So if you could please answer the question. Repeat your questions, Steve.
Thank you, Your Honor. In the lawsuit that you currently have filed in Newport News Circuit Court, you have named Dr. Ebony Parker as a defendant, correct?
Correct.
And in that lawsuit, you are suing Dr. Parker and the other defendants for money, correct?
Yes.
Okay. And you and several other parents share the same attorney, correct?
That's correct.
Yeah.
And you believe that a criminal conviction of Dr. Parker will help in that civil lawsuit, don't you?
No.
Okay.
Good answer.
Have you made any other demands of Dr. Parker or the other defendants?
No.
Okay. Do you know when that lawsuit is scheduled to go to trial?
No.
Okay. When was that lawsuit filed?
I believe it was February of 2023.
February 2023?
I don't know.
Okay. Okay. No further questions, John.
Just a couple of more questions for you. As a result of the incident on January 6, 2023, and all of the things that your son has done, have you spent money?
Yes.
I'm going to object to go beyond that cross-examination.
I think that's right on point with the cross-examination. He asked if she was seeking money in a lawsuit, and I think it's very fair for me to ask if she also spent money as a result of the incident.
I'll allow you to proceed.
Did you spend money as a result of what happened to your son?
Yes.
All right, thank you. I don't have anything further.
Anything further for this witness?
No, Your Honor, I ask that she be released.
Any objections to her being released?
No, Your Honor.
Thank you, ma'am. You are excused as the witness. You may stay in the courtroom or leave the building. Next witness.
The next witness will be Ramon Gonzalez. Your Honor, I anticipate having this witness plus one more.
This witness plus one more. Okay, so there's two more coming. And all that we is Victorious wants to bring me home fried mushrooms. And I'm like, yes, please, but you don't get home until 5:30 in the morning, and that's like freaking what, 7 hours, 8 hours from now. They're not going to be any good. Love you, babe, but love some fried mushrooms, but 8 hours later they're going to be a little mushy.
Do you swear affirm the testimony you're about to give?
Oh, here we go.
Whole
This
truth
was
and
the one they were
nothing
making
but the
fun of.
I do.
That chat was dogging on this guy, and that wasn't very nice. I didn't like it.
Thank you.
Good afternoon, sir. Would you
Good
please
afternoon.
tell us your name?
My name is Ramon Sebastian Gonzalez Hernandez.
Thank you. And I would like to
No gum, sir.
just a quick reminder that during this trial, we're not speaking the names of any children at all and only using initials. Do you have a child?
Yes, sir.
What are your child's initials?
GG.
And did your child attend school? Did Gigi attend school in January of 2023?
Yes, he did.
What grade was he in?
First grade
And where did he attend school?
at Rich Neck Elementary.
Do you know who his homeroom main teacher was?
Yes, I do.
Who was it?
Abigail Zwerner.
All right. Did there come a time on January 6, 2023, when you had to unexpectedly go to Gigi's school, Rich Neck?
Yes, I did.
And when you arrived at the school, did you immediately see Gigi?
No, I did not.
Okay, stay with me and let me walk you through it. Okay, so eventually did you see Gigi at the school?
Eventually, yes.
And when you saw him, could you please just describe, without saying anything that he said, describe his demeanor, how he was acting, and how he appeared to you?
He walked out of the school with a look on his face like he had seen a ghost, pretty much. I was crying myself. He wasn't crying, but he was in shock, like complete, utter shock.
Okay. And from that moment forward, did you notice any changes in behavior from Gigi as opposed to before January 6th?
Yes, at home he was a little bit snappier with his brother. Whenever they would argue, he would be a little bit more aggressive. Other things like he had to sleep with him every night because he just felt more comfortable. Bedwetting almost every night. Things like that.
And were all of those things new after January 6th?
That was new after that.
Okay.
He loved to sleep by himself before that.
And did your family seek some help and treatment for Gigi?
Yes, we did. Right after the incident, we went, I want to say 2 or 3 times. Mm-hmm. And he was very adamant that he didn't want to go because we wanted to keep his life as normal as possible after the incident. So I wasn't trying to force it down his throat,
Okay. And has he, at any time between then and now, has he sought any treatment beyond that?
Not since then, no.
Okay. And how long did, any concerning behaviors that you've described last?
It still lasts to this day. Getting better gradually, I think. But still, he has a lot of mood swings. And the whole big wedding thing happens. Yeah, it's pretty rough.
Did your family incur any expenses as a result of this?
As far as with the
for Gigi, as a result of this, did you have some expenses?
No, with the therapy that was provided, so we didn't have any expenses as far as that.
Okay, thank you. I don't have anything else for you.
Thanks.
Good afternoon, Mr. Gonzalez.
Good afternoon.
You weren't at Rich Neck Elementary School on January 6, 2023, correct?
I picked up my GG that day.
But you were not inside of the building, correct?
No.
You learned about the shooting after the fact,
Mm-hmm.
of course. Did the school contact you at the time of the shooting?
No, I had a friend of mine, a coworker, contacted me and told me about the shooting.
But did the school ever contact you?
Afterwards, yeah.
How long after?
I would say an hour and a half.
Okay. Your child was not in the classroom where the shooting occurred, correct?
Yes, he was.
Okay. And you're saying he was a student in that classroom?
He was a student in Ms. Zwerner's classroom.
Okay. And you filed a civil lawsuit in this case, stemming from the events of January 6, 2023?
I don't feel comfortable talking about that.
And Your Honor, I'd like to note my continuing objection.
Okay, so noted. Sir, you do need to answer the question, please.
Yes.
Okay. And you have named Dr. Parker as a defendant, correct?
Yes.
All right. You're seeking money damages from Dr. Parker in that case, correct?
Yes.
Okay. And a criminal conviction of Dr. Parker would be helpful to that lawsuit, wouldn't it?
I'm not sure about that.
Okay. No further questions, Your Honor.
No, Your Honor, I ask that he be released, please.
Any objection from the sentence?
No objection.
Thank you, sir, for your testimony. You may step down.
Every one of them, they are all in on that civil lawsuit. Almost everyone they have brought up.
Thank you. Line up.
I understand. I understand. I will take a.
I know that gum. I wanted to rip that gum out of his mouth. Rip that gum right out of his mouth. But this goofball over here, Mr. Prosecutor, got a pen problem, and I'm gonna break his pen before this trial's over with. Okay, this is last witness. Last witness, then we all get lemon pound cake, and we all get to do our hugs and say goodbye.
The witness stand, watch your step, chair and microphone are adjustable. You may proceed.
Good afternoon. Would you please tell us your name?
Hi, Sarah Gonzalez.
Ms. Gonzalez, do you have a child?
Yes.
Remember that we're only using initials or referring to your child as my child. What are the initials of your child?
G.
And who is Gigi's father?
Ramon Gonzalez.
Okay. I want to take you to January 6th of 2023. On that afternoon, where were you when you first see Gigi?
Guess what?
After the incident, when I saw him.
When you first see him on January 6th, 2023.
At our home.
Okay. When you first see him at your home, is it still on January 6th?
Yes.
And do you know roughly what time it would be?
It was in the evening.
Okay. Could you just describe for me, without telling me anything he said, but could you describe his demeanor, how he appeared, and how he was acting toward you?
When my husband came home with him in the car and he came out, he was like he had seen a ghost, kind of. He was white and his eyes were really big. And he was just kind of, I've never seen that look before, but he was kind of like he was in shock.
Okay. Were ongoing after that day, were there any issues with Gigi that you noticed that were different than prior to the January 6th?
Yes.
Describe those to us.
He had, he couldn't sleep by himself anymore. He had to sleep with someone else, and it just is, to this day, he still sleeps with his older brother, and he just refuses to sleep by himself. And he frequent bedwetting started occurring after that, and frequent bouts of losing his temper, and
right,
just
case
being
one.
angry, things like that.
Yeah. And for how long did those things last?
For a long time. It's improved. I would say, but it still occurs. It was very frequent after that for quite some time.
Were there any other major life adjustments that your family had to make as a result of what Gigi went through?
Just trying to internalize it and, move forward. And, it's the impact on my husband and myself. It was pretty significant and caused a lot of anxiety and,
I agree, Judge. We won't go down that road.
Okay, so we won't consider that just to the child. Next question.
I don't have any more questions. Thank you so much. Please answer any questions from defense counsel.
Good afternoon, Ms. Gonzalez. You have filed a civil lawsuit in this courthouse as well regarding the events of January 6, 2023, correct?
I don't feel comfortable speaking on that. as it's relevant to my son.
Okay, objection, no, anything.
I knew this was coming.
You have filed a civil lawsuit related to the events of January 6, 2023 in this circuit court, correct? And you have named Dr. Parker as a defendant in that matter, correct? And you're seeking money damages from Dr. Parker and the other defendants, correct?
Am I still liable to speak on this?
Yes, ma'am, you need to answer the question, please.
Yes.
Okay. In fact, you and several other.
Case one, I'm gonna look it up tonight during the night. I'm gonna see what I can find on it. I want to see how many people are involved, if I can find the civil lawsuit and how many people are involved and stuff. I've they've got me fucking being nosy now. It's one of those I need to know. I need to know. And I keep, I'm sitting here with a smile on my face, but in my heart, I'm thinking this woman they're just traumatizing these people all over again and again and again and again. It's like, wow. Cindy says they should have compared notes. Hey, you say ghost. What do you say paler? What the Cindy, I think you're behind about 2 minutes.
Parents are represented by the same attorney, right?
Objection, Judge, that is not who they are represented by.
Attorney, okay. In fact, you and several other parents are represented by the same attorney, right?
See? Oh.
Objection, Judge, that is not who they are represented by in the civil suit. It's not in any way relevant.
I think it's relevant. We have a series of witnesses, all filing civil lawsuits, and represented by the same attorney. I think it's totally relevant to these proceedings.
And I object to counsel saying they're all represented by the same attorney. He's not testifying.
Correct, that's not evidence.
Well,
I'm going to sustain the objection. Who their attorneys are, it is not relevant. But, that their lawsuit is relevant for cross-examination. Next question.
And a criminal conviction of Dr. Parker would help in that lawsuit, right?
Right, Cindy.
What was your answer? I'm sorry?
Yes.
Okay. So you have a financial interest in these proceedings, right?
Oh my God. Say no. Say no.
I imagine that's part of it, yes.
Okay. No further questions.
Oh.
That's all for this witness, Judge, and I would ask that she be released.
Any objection? Okay, ma'am. So you are excused from being a witness. Thank you for your testimony. That means you can stay in the court or you may leave. And watch your step as you step in.
Judge, may I have just less than 1 minute?
Yes, sir.
To confer.
You can step down. Thank you, ma'am. And Sheriff will direct you.
Is that it? There's 3 minutes left. What's happening? And then we're getting to some pound cake. Every time.
Your Honor, the Commonwealth rests.
What? He rests? The Commonwealth rests. Y'all, they rested. So we're going to be on defense tomorrow.
Your Honor, the Commonwealth rests.
Your Honor, we will have motions to strike, but I do want to take time with my co-counsel and the defendant to make sure that we have every base fully covered. So I'm going to ask the court to consider going on recess for the remainder of the day, and then we'll come back first thing tomorrow and make our motions and present any evidence on behalf of the defense.
Come on. In terms of proceeding in that chronological fashion, your position.
I'll submit to the court.
Okay. All right. So, to the jury, we take up the motion to strike outside the presence of the jury.
Okay. Well, with that, let's just carry on and get to the...
Adams County Sheriff kicked down my door. Then I heard the glass spray. They found no kidnapping victims, just some lemon pound cake. Mama's lemon pound cake. It tastes so nice. Adams County Sheriff. He's hungry and he's big as hell. He was sniffing for weed, then he smelled another smell. What was that? Mama's lemon pound cake. It tastes.
Guys, it's been a day. It's been a fun day. We've been here for 5.5 hours. My dogs miss me. As you see, we've had dog fights, we've had cheese tacks, we've had playing on the bedtime, we had nap time with Lola. I mean, if anybody could put on a crazy ass show. Hello, ding ding. It's been a ride. It's been a ride. But before we go, as always, don't forget.
You is smart. You is kind. You is important.
I want you to know I appreciate every one of you for hanging out with me. So we'll pick this back up tomorrow, same time, same place, 4:30. We'll be hanging back out in the Rubber Ramada Reviews room with our feet in the duck pond where we let shit just roll off our back. We say what we want to say and enjoy each other's company. Till tomorrow. Peace. Rubber out. Y'all have a great rest of your night.
We'll be right back.